ಕೋರ್ಟ್ ಆಫೀಸರ್ ಆಡಿಯೋ ವಿಡಿಯೋ ಎರಡೂ ಇಲ್ಲ. ಕೋರ್ಟ್ ಆಫೀಸರ್
ಸರ್ ಕೇಳ್ತಾ ಇದೆಯಾ?
Tomorrow, all the second up is tomorrow. Should only on Wednesdays. Wednesday. Monday, Tuesday, we pick up labor matter. Motor vehicles only on Wednesday. Huh? But in the preliminary hearing, what is it? Preliminary hearing, we only listed in on Wednesday. No, we'll see, we'll see. Not heard this matter, right? Wednesday. Nade. Adu month, Wednesday.
Well, clearly this is another KB matter. Mallots in the last day they submitted a memo. Mallots is third matter. The matter will be listed next Wednesday. Please.
What interim order you're pressing for? What is the interim order granted? Party interim. Both of them will be having one or the other day. Let us see. Not tomorrow. Friday. Friday. Yes. Fine. LV matters, really. It's not before this court. Local bodies are not before this court.
May.
There is a memo. We don't know what has happened to that memo. There is you have to move a memo, Mr. Khan. 2 months back, 17 days. At request of the petitioner counsel, list this matter on Monday.
May I make a mention, my lord?
Just a moment. We are calling.
Please, ma'am.
Number 7, serial number 30. Serial number 8, serial number 30, 26.
Serial number 23, my lord.
23.
You'll actually kindly take it on Monday, my lord. I have to address arguments. Monday I will address arguments.
29.
Most of them.
Serial number 37 to 43. Page number 10, serial number 44 to 49.
Yes, at request of the petitioner counsel, list this matter next week. Week after next.
Page number 11, serial number 50 to 54. Page number 12, serial number 54 to 55.
My lord, serial number 57, my lord. I am appearing for petitioner in this, my lord. I kindly pray for a week's time. 57.
Request of the petitioner. 50?
7.
Week after next. Question, this is not a week after next. If you not have granted, earlier is extended to the next. At request of the petitioner counsel, this is not a week after next.
My lord, serial number 57, my lord.
61. You appear to. File here.
Serial number 11. Steve, it down to 8 of the rules 1990 is ultra-vires. The extent that permits heavy and loss of liquor due to evaporation and such that natural gases beyond the legislative state. Rule empowers the event that the fair is not declared the ruling of the Karnataka excise rules prospectively. Bring the for the period prior to court. Sure, it was a setting aside the order there. Inquiry to cease predicted as to the interim order dated last year. Consequently, if necessary, direct respondent to reconstitute penalty for the period beginning from 4898 in terms of Schedule B of the Karnataka rules. By giving trust to the record to 2016 amendment to Rule 8, they applying Schedule B from 48. Broadly, you have to observe the case. Two facts I want to find. What happens after we are the manufacturer, today's manufacturer of liquor. This liquor is also the output as a result of certain processes, and there you are a lot of storage takes place in the cask. So the storage takes place over a period of time. Now, because of so many factors, you know, maybe an external factor, whatever, loss does happen. So the loss happens at the stage of the spirit, not at the stage of the liquor. Yes. Now what happened here? Also kindly look at the rules that were framed. 49.
Where did you find it?
Page 49. The same petition. Looking at the petition 20817.
Is it? There's only one writ petition, right?
Yes, there is one your lordship where I have moved a modification. I have referred to it slightly. That's not page 49, your lordship, is the Karnataka excise regulation of meat production and wastage of spirituals. Now, this essentially your lordship is to monitor the wastage of spirit and wine, etc. Also comes page 4. The maximum permissible wastage during the production or processing of spirit, beer, wine, or liquor as the case may be, from the raw material used in a distillery shall not exceed the quantity specified in distillery. So I can have only so much of loss as a sheet. Not to have a look at Schedule B. If you want to find that page 54. The concern your lordship 3 at 55. Down below your lordship, maturation loss. Down below, secondary.
Yes.
Loss of maturation or reduced blended or compound spirit for manufacture of alcohol. Loss of kindly see, this is more. Substituted by notification dated 23/7/2017. It becomes fluid. So this allotment was the percentage of loss which we had indicated. So it is 6 months in the period of consideration, loss should not exceed 5%. 12 months 10%. So various periods, various percentages are indicated.
What is the period of maturation in your case?
Depends on various.
So in the present case,
What different periods are there? Different periods. Now, this percentage is not vary over the documentation. You also see over the page. Different periods, different percentages. Now, this notification your option is from 2016. Before that, your option is percentages is slightly less. Now, what happened your option? How my lords can come directly to the improved order that sets out what has happened to this time. Page 32. Order your lordship passed on 13/6/2004. Lords will get the date in the end of May. Page 48, we not to get it. There are three. I'll read two paragraphs is all I want. That's all why. The audit team, the Accountant General in Karnataka, have conducted audit of its area for the period 86-87 to 14-7. Also, very notice period. 86-87. 14-17. The rules are actually found in 1998. The lots are earlier. That's all in 1998. The aforementioned independent notices for these 9 crores was issued based on the observations made by the auditors from the office of the accountant general. Out of the 15 audit paras, 12 audit paras are already before the public accounts committee and yet to be decided. The year-wise details of the pending audit para numbers and the outstanding dues as observed by the RS below. Starts from 86, these are all audit paras from 86, 2014-17. 15 audit paras have a total liability of 9 crores. So in this year, 12 out of this 15 are still before the public accounts committee. We have no information about what happened with that. It's before the public accounts committee has said it. We have no. Now, reference paras raised by the audit team all pertain to loss of spirit stored in cask for refrigeration for a longer period, excess wastage of spirit during the process of refrigeration. Of the above 15 audit paras, the first 11 audit paras pertain to duties. And the audit observations are based on the government order number dated 16/5/18. Audit paras 12 to 15 pertains to the year 1998-99 and are based on the government notification number 4898. This was the earlier notification that prescribed the various percentages. Then my last can come directly. They created a demand here also, we filed an appeal. So lots will see on page 35, page next. The appellate authority in second paragraph, in appeal number has passed the following order. The appeal is allowed. Demand notices bearing number, dated and so on. So are hereby set aside. Pending inquiry to be conducted with excess commission as per rule 8 of the rules 1998. So the original demands of 15 paragraph by virtue of this appeal was set aside, but on the ground that you have to conduct a certain inquiry. More importantly, I want to use he canvassed an argument before the authority that they have got a notification of 2016. This 2016 notification is different percentages. This substitutes the earlier notification. So it will take the place of the original notification. So if you take the revised notification, most of the losses will be 50% twice notification. But the appellate authority takes a view that this notification is only prospective and not the prospective. So we find a repetition. The next step. The Honorable High Court of Karnataka, in its interim order on 1 of 2005, that was earlier issued the following direction. These circumstances are considered. The court will consider the renewal of the petitioner's license cannot be the existence or realization of personal service, which is not even crystallized. And therefore, there must be a direction to the Commission of Excise consider the petitioner's application for renewal without insisting for compliance report as called for application, while simultaneously calling upon the Commissioner to hold an inquiry after opportunity with the petitioner and decide on the petitioner's liability equally according to what's pending of these 3 sentences. According to the Schedule B, as it stood prior to the subsequent notification, as well as the scheduled substitute Schedule B. They were not said, look at their losses, see the revised notification, have a calculation as per the revised notification. Then they said, have a calculation as per the previous notification. Now, previous notification will have 2 buckets. So, the prior to 98 and after 98. So, 84 to 98 is one bucket, 98 onwards is another bucket. And then if you apply the 2016 notification, what happens? What the direction that was. You also see the order. Commissioner 2 of Excise shall consider the petitioner's application for a claim to the system of compliance. But the Commissioner 2 of Excise shall also simultaneously commence inquiry for the petition. Decide on the petitioner's liability according to Schedule B as it stood prior to the subsequent petition as well as the subsequent. C. The inquiry shall be completed within 8 weeks from today, and the outcome of this inquiry should be subject to further orders of this court. But in the event the petitioner is found liable to pay any amount according to the Schedule B, as stood before substitution on 23/7/2016, the petitioner shall avoid any adverse orders which impede the operation of license, deposit the entire amount so determined to the Commissioner of Excise. The petitioner shall deposit the amount as opposed within 4 weeks date of substitution. It's clarified that even this deposit is subject to approval. Yes. In the pursuance to this order, notice the solution as per rule 8 for their case.
Yes.
Now, particular I stop here for a minute. What happens is after this, the order is passed and they can also be ordered.
What happened to the writ petition which was there?
Specifically, because we have challenged the first order by the appellate authority holding that this notification is being crossed up, but not the cross up, that is pending. But this
Now, in light of the directions
Yes.
issued on I-1 of 2023, are you not required to go and
Yes.
approach the very court? The writ? What happened?
The operation of the license was it the entire amount shall be given to the Commissioner of Excise. Petition shall deposit the amount as opposite to the date of such determination. It's clarified that even this deposit of the Congress with this matter case of license was not written. There was insistence. In full sum of the pass this order. This is incredible. This order was out. First, how that order was also after interpretation. What's the matter that well on application? What's that? I can deposit some of them, not simply the renewal. Now, if they are operating on the basis of the renewal, they have to notice the condition that the court imposed that you must deposit the entire amount has not been applied till date. What's that? Without deposit, I am not going to hear this petition. Then what can it notice the final application seek for modification? It come across, it was heard towards clear. Thereafter, it was Procedural order was passed by on Court had directed towards this is the first order. Notes in the same order. They stated that an application has been filed for modification order. So, last one. Prior to the earlier petition, was forced to declare that the public would personal demand. So, the penalty for any entry of passport with operation, given purposeful use. Now, what we do is now the order of the excess commissioner can be challenged either by way of amendment or by way of suspension. But the other action modes of challenging the constitutional validity is available then also for the order to be applied. But I'm not taking up those contentions now. You are to opposing the increment or all I'm saying is some compliance with this order. They cannot first seek for any interim order at the hands of this order. Let them come. Whatever my learner if you are free to the max. Reason you are why you move a modification application. Two reasons you are why you move a modification. The earlier order is not sufficient.
So this order came to be passed, the interim order came to be passed by the commissioner in light of the specific orders of this court on IN number 1 of 2020. Is it not?
Yes, but the court directed, what the court directed is what? Please calculate the liability in terms of the.
Absolutely. Correct.
After holding an inquiry.
The court gave certain directions. Okay. And in the operative portion of the order, it mentioned that in the event the liability of the petitioner has been decided by the commissioner, the petitioner has to deposit the entire amount which has been determined by the commissioner before the court, and on such deposit that would be always the subject to the outcome of the final.
Has to take.
No, that is available for you to be addressed before.
That is why I said what this order directs us to deposit subject conditions that is how you should do. The officer could have done
This all is available to you to be made by way of a modification which you have already sought in that IA.
Yes.
How is this writ petition maintainable?
This petition you want to file challenge the present order.
You can challenge the, no, that is how it is. These are all correlated.
Both the petitions are also for the same cause of action as well as I am concerned. Original liability. I have a difficulty. I would have filed the original petition. I can file an amendment petition. Include this order and original. Seek all the prayers. In amendment of the prayers in respect of what we have done here, I can do that. I have absolutely no difficulty in all that. So this petition, after suppose we leave for the petition, this petition may not survive also. But go on that day. What I am today submitting is this order is passed creating the same liability and proof without adhering to the directions directed. The court directed him to look at three possible scenarios and give the calculation. To hold an inquiry and do the calculation. Both are not being done. Now, of course, this interim order stays at my face. Therefore, your option we have moved a modification application before this option to say that please look at your order. Please look at this. Please only modify your clause of your earlier state. Allow me to go back to the court on the same issue, asking for a stay that your interim order has not been applied with. Therefore, my submission today, your option is actually we were trying to get this modification application earlier. We could not do because what is in Harvard.
Whatever.
Therefore, your option still such time this modification application is right. We want your option to security stay The moment the recovery, the moment the modification order is
There
passed.
cannot
what
be,
will the
there
consequence?
cannot be a parallel proceedings. When you have already raised an issue before the another, in another writ petition, when there is already an order directing you to pay certain amount or deposit the entire amount on determination. So the court assumed that there would be a determination.
In the manner in which the
No,
lordship-
whatever. See, that is available for you to urge all the contention. But this court would not entertain this writ petition at this stage. You make all your contentions. in
I
that.
do all like your lordship, but the only difficulty today, your lordship, the other interpretation also will come before my lordship. The other interpretation also will come before my lordship.
It
Because
can,
of the-
it can, yes.
they come before
Well,
my
that
lordship.
doesn't mean that this court can entertain this writ
No
petition.
issue, your lordship. Our difficulty today, your lordship, is only this. There is a determination done based on an entry order. Now that determination according to us.
We cannot go beyond the order which has been passed by the,
Unless the
until it
lordship
is modified.
Exactly. There
So,
won't have moved this modification.
Then you have to press for the modification.
So
Then it is at we cannot.
We did not prove the laws at this stage.
No, it's not the question of trouble, it's the question of as to how the proceedings have to be proceeded.
No issues, Your Lordship. I only submission in order this. We are pressing for a hearing of this modification.
No, we cannot pass an order which is contrary to the order passed by the coordinate bench of this court. And when an application for modification is already pending.
Yes.
And this court,
Submission to us. Today I have a situation where I have moved from modification to order.
you are asking this court to sit on an order of a coordinate bench of this court.
I have moved a modification.
Then go and approach the court. which-
Because he not pass an order on this. I will go see what happens, modification. Depending upon the orders that are passed on modification.
This court is not inclined to grant you any interim order in this petition. Not in this.
I press for modification, yes.
Before this court. See, you can ask for extension. There are so many provisions
I
available.
don't know what stares us in lordship is the order passed on the.
Aware about it.
You restrict your lordship by the move is earlier.
You want this court to pass any orders now in this,
After this.
after hearing the matter for some.
Today your lordship will not pass an order. Then tomorrow morning, the lordship will sit for 9 lakhs and he won't come.
He has moved an application for modification. Don't precipitate that matter.
What I'm saying.
Don't precipitate immediately. The reason is, ultimately you want some amount, right? So let him deposit.
More important, your lordship, 12 out of the 15 paragraphs, see my situation here. 12 out of the 15 paragraphs are because of the concern. You don't even know whether they will survive or they will not will survive. And the notification today is.
No, any order which would be passed now by this court would be on the fact that this petition is not maintainable. You have to go and approach
My
this.
submission, your lordship, two things only. I would very grateful, your lordship, if they don't precipitate an action. Let them, one submission I want to make. Let them precipitation notice was not renewal of license. License is renewed for 24-25 days back. That's why your lordship. Pending for the board, it is okay.
No, you know the court.
I
this
don't
or
have-
not.
We have done that, your lordship. The books of record, but they are not compliant to the order.
And you can seek for an extension by way of some other few weeks for depositing of that amount. No more orders now in this.
Saying this, your lordship, that you have renewed the license, no difficulty, I am grateful for it, but you simultaneously issue a recovery in the beginning. Is there ever difficulty here?
Now, how can we pass any orders? That is how this court has informed the AAG. That
I
is
will move the other high court, your lordship, for prayer accordingly.
your senior counsel. Shall we say that we have heard the counsels or we just adjourn it? At request of the petitioner counsel, this matter? Whether? You take notice for that. Alla beda. See, this petition itself is not maintainable. Once they get a modification order, they will be.
Then I will.
Or should we say that you will take notice for the, you appear for all the respondents? SCGP to accept notice for the respondents. Then at senior counsel appears for the petitioner, and AG for the respondent. At request of the petitioner, list this matter after 2 weeks. So 4 weeks.
Bill number 2, the Sharat S. Gowda.
Mr. Sharat Gowda. How is this prayer maintainable, Mr. Gowda? How is it maintainable? Second one.
Second one, what I want to say. What for me?
What is this prayer?
Petition number 1 to 4, that one of the residential site. It's like not they would take time and plan and they immediately develop also to temporary electricity connection. For developing the entry into JDA with one sound. It's strongly.
There was already an electricity supply to your. When was it supplied? When was it supplied to you?
When we applied for plan and license, at the beginning of construction.
While constructing the building, you had.
Page 36. 13th October 2023.
Yes.
It's the logical tendency. For the purpose of building in the site level, entered into a joint development. One zoning. Zoning entered into a subcontract with one subsidiary constructor. The proprietor is called Mohan of the construction.
You had purchased half or.
So, the petition number 1 to 4 jointly purchased the entire site, residential site. They entered into the area, now subcontract was extended. 10 flats were constructed. Out of these 10 flats, 4 flats went to the share of the owners, 6 flats to the share of the developer. That is the sharing level. Now, this developer and the subcontractor, there arose a dispute. How the amount developer and the subcontractor. This ended in filing of a civil suit, OS file. In this OS, Schedule A property was the entire residential site, and Schedule B property was only the flats which were allotted to the share of the developer. Initially, price was granted in respect of entire Schedule A property. We were aware as depend number 2 to 5 in the 2. We filed an application seeking for vacation of the property. Price was not completely vacated. Yes, this is only in respect of money between the developer and the subcontractor, and these persons have nothing to do with it. And it also says so far as possession, no interim order is. We are not going to be paying now. Page number 120 minutes per minute. Defendants are restrained from alienating only Schedule B property. The Schedule B property are the plans which are to the developer share, not to the share of the owner. Next, IA number 3 filed by D2 to D5 is allowed in part. At 121, the status quo order is modified and vacated insofar as possession is concerned. It is made clear so far as possession is nothing. Plaintiff give for temporary in respect of not modified in the possession of which is rejected. This is the order. Now, my lords, after this order, we moved an application. The trial court order is modified. Please grant the electricity supply. That application, my lords, your lordship will get at page 196.
Was it an order of not to alienation or only in respect of?
Not to alienation is the order which is granted in respect of Schedule B property.
Schedule B property is the property which is pertaining to you? No. Yours is?
My flats are flat number.
No, whatever has been granted by the trial court is not pertaining to you. That is
yes, yes. My flats are 101, 102. 1, 2, 201 and 202. 1, 2, 201 and 202 are the flats which are fallen to the share of the landowner.
In number 1 was filed by the plaintiff for not to alienate the property. Then I number 3 was filed by you. In so far as
vacating the interim.
And then status quo order was modified and vacated insofar as possession is
concerned. Entire property only is vacated because well said what we do with possession or not in possession, let the possession with the developer.
What is the order on your application? What is that? What is that?
It only means they only demonstrated so far as reaching property.
What was your IA number 3? Just show
my IA application. At Alexia J, page 9.
Page 9. Page 9.
90.
Okay, what is this? The interim order of status quo? So
Page
and so.
90, page number 3. Where the it is to vacate the interim order of status quo granted by the dishonorable court on any.
What was the order of status quo? Status quo as to possession, no, just status quo.
Status quo as to possession as well as alien.
Alienate. So now I number 3, which was filed by you, was allowed in part, and status quo order passed by the court on so and so was modified, and it was vacated in so far as possession.
Possession is concerned. Therefore, possession is respect to eight agreement. Because that I also showed it slide 2. Not in the edit take addiction.
Page number.
Page 76 slide starts.
Yes.
Page
Yes.
76. And in this part, if you not take
This is a suit filed by the Saptagiri Constructions against this Somya.
So we
owner.
have also made a formal party. You are not even now we take up to page 18. Page 18. Paragraph 12. Defendant has agreed to register the said file that apartments in the name of plaintiff in order to complete the development of the said property for which another MOU was entered and executed by plaintiff and defendant number 1. We are not parties to this MOU for this appointment. And hence, flat apartments bearing respective door numbers in the suitable property in the name of plaintiff clearly stated in the MOU in the details of the department as follows: 101, 301, 302, 401, 401. These are the date sheet. Indemnity property is this. Now, if your lordship takes it, page 85, your lordship will also see the prayer as well as the schedule A and schedule B property.
Where is the IA filed by them?
Are you fine with?
Yeah, the plaintiff.
That I am not positioning.
So the IA, where is the order of status quo? Of the trial for. Now, what is that you're before?
Now, your lordship may kindly see. Now, my lords, I made an application saying that this order is modified. Please grant electricity supply. Nevertheless, even if there is dispute, in Bangalore, all the sites are in dispute. How can they stall the supply of electricity supply, my lord, which is
On
a
what
essential
ground?
commodity?
On what ground they have been denying you this?
So, on the ground that there is a civil case, your lordship can now kindly take annexure. M.
Now it is disconnected or they have
It is
not?
not. Only temporary connection was given. They have to give regular connection.
The building is completed.
Your lordship will kindly take annexure M for a moment. Page 186.
This temporary connection would be continued till they give you permanent, right?
Yes.
Now it is continued.
Now, my lords, we are really residing there by making of generator. They have disconnected the temporary connection.
So we'll ask them to supply you electricity.
Yes.
Who appears for the respondent?
Any panel council, my lords.
Who's the panel
Okay,
council?
for this strong.
Who is the BESCOM council?
So they are the.
S. Devarajan. Leonard council is directed to accept notice for respondent number 123. SCGP to take notice for respondents number 426. 426. Amendment 123 minute petitioner counsel to serve the writ petition papers on the learned counsel. Learned counsel for the petitioner submits that there was a dispute between the developer and subcontractor in OS number 190 of 2023. And then, you take notice then. Monday will be. Monday. SCGP takes a note. This matter on Monday. Monday instructions for now. We'll dispose on this matter in preliminary hearing. Can get instruction. Yes, Mr. Sunai. Why this application under section 482 of the Code of Criminal Procedure? Why did you file that application? That is I1 of 2024. It is not, it is still there. I1 of 2024 is filed under 482. Why 482? Allah, 482 ಎಲ್ಲಿ ಬರುತ್ತೆ? 482 oversight. Correct. Oversight can be 151, 152, 153 as if you feel, but not 482, right, in this petition. Only 151 alla barodu dispensation, no? Yes, what is now you are seeking for?
And obtain the middle property by the owner. The year 1986. Later, he gifted the same property to his wife.
Now, what is the impugned order? By way of impugned order, what are they trying to do? They have disconnected or disconnecting?
Disconnecting yesterday. Okay, I have tried yesterday, it's a repetition. In the afternoon, they have disconnected, taken my.
Yes, Devraju. You take notice for the restore their electric connection. Look at the way the authorities do. They issue a notice on 3/9, immediately they disconnect. And what is the ground? What is the ground for them to disconnect? What is the ground available to them to disconnect the electricity?
I am passing 3/9.
So Devraju, one day we will disconnect the electricity of your concerned officers. They will realize only then. Let them stay in dark for some days. ತುಂಬಾ ಅರ್ಜೆಂಟ್ ಅಲ್ವಾ ಅವರಿಗೆ ಡಿಸ್ಕನೆಕ್ಷನ್ ಮಾಡ್ಲಿಕ್ಕೆ? They are so much in a hurry to disconnect. Huh? ಅಲ್ಲ ನಿಮ್ಗೆ you are so concerned about any civil dispute and all that. Huh?
In 2020, the civil dispute is there. For 3 days, they have not, one Joseph has not given any complaint. 2020. The year 2023 only they have taken.
On the complaint of one, who is that complaining?
This is 10 days.
You
They
make-
have claimed that I am the one of.
Yes, H.D. Devraju is directed to. Illegal idra, it is for the authorities to take action in accordance with law. How are you concerned to disconnect their electricity supply? ಯಾರು? ಅಲ್ಲ, that is a civil dispute pending. Let it go on. Who is in possession of the ಕೊಡ್ಬೇಕು? H.D. Devraju is directed to accept notice corresponding petitioner counsel to serve the writ petition papers on the learned counsel. Learned counsel for the petitioner submits that the petitioner is the absolute owner in possession of the scheduled premises, and she has built a dwelling house along with 3 shops and is living, and she is living with her 2 minor children in the said property. After obtaining power supply from the Westcom. It is the contention of the petitioner that the Westcom has approved and given power supply connection in 3 different meters. And the petitioner has been paying bills on time. On a complaint of one A. Joseph, who has instituted a suit for permanent injunction against the petitioner in OS number 242 of 2020. The assistant executive engineer has issued a notice stating that the petitioner has constructed a building in violation of the building license, in violation of the building license. It is further stated that the BESCOM authorities have issued the impugned notice with an order of disconnection of power supply of the petition premises. The petitioner files an application before this court today, stating that the representative of BESCOM on 17/9/2024 entered the premises and have disconnected the power supply or to the petitioner's building, and also the electric meters, and also taken the electric meters. Yes. The application filed by the petitioner is taken on record. The providing of electricity supply is the basic amenity for the citizen to live with dignity. The respondent number 2, at the behest of one Joseph, and on the contention that the building has been in violation, the building constructed is in violation of the rule, violation of the building plan, cannot be a ground for the respondent number 2 to disconnect the electricity supply or connection to the premises. In the said circumstances, the respondents are directed to restore the electricity connection to the petition building, petition premises, and also and the petitioner to continue to pay the consumption charges by refixing the meter forthwith. Give instructions to your concerned forthwith ಅಂತ ಹೇಳಿದ್ರೆ. We have directed them to give and the respondents not to take any, now that he would restore its title. Confuse the court also. ಅದು ಹೇಳಿದ್ದೇನೆ. So we have directed them to restore the connection. And delivery. Madhyana. Yes. And delivery permitted.
Bill number 4, Siddharth Suman.
Yes.
Direction part of the predecessor. It says that even if NIC were to facilitate it or not, there is a writer to it. It is made clear that since the state government is agreeable to register vehicles of the petitioners as contemplated.
Where do you find that order? Which order?
25/7/2024. I would read the last paragraph. It is made clear that since the state government is agreeable to register the vehicles of the petitioners as contemplated in the scheme of state government, it would be obligatory on the part of the state government to register. So NIC will be appointed. That's it.
No, what is your contention? Kindly tell the facts.
There are notifications.
Oh.
My tractors used to come in Bharat BS3A. That is so far as agricultural tractors are concerned. There were 2 notifications passed by me.
First notification was?
I will just take Malad for NIC, I think said A and B. But in fact, I have also produced another memo. If my laws were to kindly see, I would fall into 2 categories, that is 4 and 5.
See, you were registered as a temporary
I have not, because the notification does not provide.
Which is the notification? Which are the 2 notifications which would be to your benefit?
Annexure A and Annexure B, there is a timeline, my lord. Now I had to get this registration done by.
This Annexure A is issued by the state government.
No, my lord, all central.
All central.
All central.
Annexure A. So as per Annexure A.
My lord, may kindly come to Annexure A, page 20 and page 21, my lord. 20, and if my lord were to kindly see page 21, now, my lord, I would fall into both categories. That is 4 and 5. Because, my lord, I would, insofar as kilowatt is concerned, it comes in 37. My lord, may kindly see in table 1, 37 kilowatts. If my lords were to kindly see the first category, 37 kilowatts still about until 56.
Yes.
Then my lords may kindly come to table 2, 37 to 56. I come into both these categories. Mine is 51 kilowatts. My lord.
Yes.
Now, my lord, insofar as table 1 is concerned, now October 2020, my lords were to kindly come to the next notification.
So you are the your factory or company is a vehicle manufacturing before the applicability of Bharat stage or after?
Because TREM 3A, TREM 3A didn't got converted to 4 and 5. Because the same category, by virtue of these notifications, became 4 and 5. Now, my lord, I fall into both categories. Now, insofar as the first category is concerned, my lords may kindly come to page 24, the second notification, that there was an extension of time. If my lords were to kindly see, October 2022, 2020 eventually became 2022. 2022 then became 1st January 2023.
So what is this cutoff date? What for what
Cutoff
purpose?
date is my lord for registration.
For registration.
For registration. Now, all my vehicles were purchased prior to 2023. Prior to this
So
cutoff
your
date.
vehicles were purchased prior to
2023, 1st January 2023, all prior to that.
2023.
Prior to that, sold also prior to that. I produced your details also to the effect.
So at the time of after purchase, you have not registered your vehicle.
But I had 6 months time. So I had certain registrations. Certain other registrations I could not do it in time.
How many vehicles? 45 vehicles.
Now the inventory is about 5 or 6 crores. So that was
Purchase-
very as it is.
So purchase before 1st January 2023, and you had to register within
Then
6
it is
months.
still 1/7/2023.
1/7/20.
2020.
So you were
It is a top date.
correct cutoff date for registration by way of temporary or permanent by July.
By July. Because
2020.
36/2023 would be the cutoff. 1/7/2023
No, no.
onwards, there's no registration.
Immaterial when you purchase the when you purchase the.
But there have been certain case laws, so which is why I would go on the case law. So far as Mehta's case, it's in there are certain other orders which have been passed, where one of the Honorable Supreme Court says that as long as it was purchased or sold prior to that cutoff date, it can be registered.
So anything purchased prior to 1st January 2023,
Yes.
you were given time up to 1st July 2023 for
months.
registration.
6 months.
Ah.
Now, my lord, my grievance is this. So far as my vehicles are concerned, now, my lord, I was not allowed to register it because I went on to the e-Vahan portal. Or when I went to the e-Vahan portal, they said that no, it is not.
When did you go to the E1 portal?
After that, because certain vehicles were.
During that interrogation.
Well, it was after. It was after because we had certain vehicles registered during that period. Certain other vehicles which we could not, because they were not sold. I could not put this. My case that I've already sold the vehicles, I've already produced those details. Now, one of the issue was this. When I tried to register these vehicles, I could not register it. E-Vahan portal rejected it.
Correct, because it was cut off
It
date
was
was.
after. Now, Manoj, my kindly see. Very similar, Manoj, again, this is where Manoj, I come to the jurisdiction article 14 and I come to that. Insofar as other similarly placed tractor dealers are concerned, Manoj, my kindly come to Annexure J directly, Manoj. Annexure J.
Page number.
110.
Yes.
Please, Manoj. In 110, if my lord were to kindly see, this is, my lord, with regard to this, the registration date is very important. Annexure J1 itself, 11th January 2024, again after the cutoff date.
But then they were extended till July, right?
Yes, till July, madam. This is 2024.
Yes.
Now, my lords, may kindly see 11th January 2024, horsepower 55.74. Exactly, even my retractors are also.
Where do you get it at column number?
My lords, may kindly see, my lords, were to see.
Vehicle norms.
Vehicle norms, please.
Yes.
The horsepower is 55.74. Then my lords, may kindly see registration valid up to 10th January 2026. Tax paid up to 31st May 2024. Now, my lord, the notifications do not provide for any subcategory to say that if temporary registration is done or if taxes have been paid, rather the temporary registration challan has been paid, you can then register it. So, Manoj, these are three, I produced three, Manoj, all very similar. One is in January, one is in February. So the state government opens up the portal for certain dealers, not for me. They create a subcategory. Now, Manoj,
According to them, what is the category now?
Manoj, this is a message which was circulated to all the dealers.
Next year?
Next year, let's 109.
Yes.
Please, Manoj. Now, Manoj, may kindly see 109. This is a message to send out to all dealers, including us. There are 7 dealers before us. Here, Manoj, the first category, so they create a category. One is, Manoj, if temporary registration has taken place on or before 30th of July 2023, an applicant has not done permanent registration yet. 2, applicant has paid the registration fee and registration tax on or before 30th July 2023, but applicant dealer did not come forward for permanent registration yet. Registration number has been generated on or before 30th July, but the applicant dealer has not come forward.
According to you, none of these categories you
I
come
do not come into these categories. Now, Manoj, we asked them, where do you get this subcategory from? They had no answer. Then, Manoj, my last process, the question to the state government saying, where do you get all of this? File an affidavit as to how you do this. They filed an affidavit saying that they go to the very same categories. Now, Manoj, where do they get it from? They also have no idea. They write to the central government saying, can we do this? Well, also, can you see their affidavit?
affidavit by the government.
By the state government. If Malaz were to kindly see para 3 of their affidavit, this is an affidavit dated, Malaz has the affidavit dated 25th July. On the very same day, the intermod was passed. They file an affidavit. Again, those 3 categories Malaz will find here.
Yes.
Malaz may then come to paragraph 4. I further submit accordingly, NIC is enabled for registration of the vehicles in January 2024. Thus, the department made efforts to register the said vehicles. I further submit that the vehicles of the petitioners are in compliance with the aforesaid norms of the rules. The department is ready to register the said vehicles if the respondent number 1, unit represented by MORT, CH, made a provision for enabling registration of said vehicles. That is where the intermodal was passed based on this.
Yes.
Again, the words used are obligatory. Now, Lord, why I could not have even fallen into this category is that temporary registration was banned from 2021. This is a fully assembled vehicle. I have produced that notification also. If Manoj were to kindly see my memo,
Memo dated?
memo dated 18/7/2024, Manoj, 18/7.
Not available. Can you furnish your
Not
copy?
recorded, Manoj. Then I'll just basically.
This is an application, right?
Yes.
That's it.
Manoj, I don't know.
Yes.
Now, Manoj, if Manoj were to kindly come to the third document. Now, this is again a notification. I've only produced the relevant. I've only produced the relevant extract mode. Manoj may kindly come to page 9 in my compilation itself. If Manoj were to kindly see 53A, application for temporary registration. Now, Manoj will appreciate that this is a notification of the year 2021, March 31st, 2021. Since then, Manoj, for tractors, this is a fully assembled vehicle. Manoj will kindly see. An application for temporary registration in case of motor vehicle is being registered in a state other than the state in which the dealer is situated. I don't want that. The next category. Or in case of purchase chassis in which the body has to be fabricated separately, shall be made electronically on the portal by the owner or to any registration authority or any other authority as displayed by the state government in form number 20 and shall be accompanied by the documents. Mine is a fully assembled vehicle. I don't have to. There is no separate chassis which put the body on. I go to the bottom of the category. State government creates a category saying that no, you can temporary register this. Now, this is against this notification itself, which is why there is no possibility for me to have done a temporary registration. And insofar as challan payment is concerned, that was never intimated to us. Where is this? We don't find this anywhere.
this criteria or this terms which they have stated doesn't find place in any of the.
My last by 20 is these are letters. These are letters issued by the state government to the central government seeking for permission. Whether this has been filed with them, there is no acknowledgement to the defect also. Whether this has been fixed to central government.
They try to fix a category for themselves.
No,
They are trying to fix a category for themselves by writing a letter to NIC. So this would be the criteria.
Yes.
Only then allow this portal to be.
yes. Now, my lord, the entire purpose of having this notification is to ensure that the emission levels are at a particular level. Now, my lord, the entire category, the entire criteria itself is changed. Because now it is not with regard to emission norms. As long as you pay the amount, then your emission can be whatever it is. So the entire purpose of the notification is defeated.
Now the state government has what's
They say
their,
no problem. They say no problem, I have registered it. Now they have labeled on the NIC. Now my other friend says that please make NIC a party, made NIC a party. So it's only a portal. Central government will then have to say, yes, I will open up a portal. Which is obligated in terms of 25/7 order.
where do you get that? Where do you get that? This is a communication between the state government and the central government. The state government, the additional commissioner says, please, NIC, allow me to register these vehicles after 2023, when if certain criteria are fulfilled. That is the letter which has been submitted to the NIC by the respondent state. Now, where is the notification? Where is the notification? No, that was the specific instructions to you that you should get the notifications, or rather you should make a submission on today itself. You can't now say that. Where is that? Where is that?
In fact, my lord, I just to assist my laws also, I produced the judgment of which speaks specifically with a very similar situation. This was also with regard to TREM 4 vehicles.
Where is
Where,
that?
my lord, the last, my lord, when you see my memo, the last document in my compilation, page 26 onwards, my lord. Now, if my lord were to kindly see the order, now this is again, so if my lord were to say that every other state has rejected the order, such as it can be done. If my lords were to kindly see the second paragraph, the issue, the seminal issue in these applications, whether the sale and registration.
Second paragraph? Page number?
Page number 26, document number 6.
The controversy.
Controversy. If my lords were to kindly see the second paragraph. Do not meet the criteria of Bharat Stage 4. Again, Bharat Stage 4 is basically what my vehicle also comes, but it also comes on Bharat Stage 5. My lords were to kindly see. The emission standards as of the 1st April 2027 takes primacy over the health hazard to increase air pollution for millions of countrymen also. If my lords were to kindly see, they wanted to prohibit registration. My lords may kindly see what the Honorable Supreme Court ended. 29. My lords were to kindly see the operative portion of the order. Accordingly, for detailed reasons. On and from 1st April 2017, such vehicles that are not PS4 compliant shall not be sold in India by any, again, the word is sold, not registered. That is to say that such vehicles, whether two-wheeler, three-wheeler, four-wheeler, or commercial vehicles, will not be sold in India by any extra dealer on or from 1st April 2017. All vehicles registering authorities under the Motor Vehicles Act are prohibited from registering such vehicles on or from 1st April 2017 that do not meet PS4 emission criteria, except on proof that such vehicle has already been sold or before 31st March 2017. Now, my lord, I have produced all the proof to show that everything is sold. I have sold every single vehicle, only registration, my lord, I could not do the order, that's it. I have sold every single vehicle before 1st January 2023. That my lords will find in my writ petition itself. Annexure E, Annexure F.
No, so similarly placed persons who have not even registered and not even followed the criteria, you you give registration by January 2024. Why do you deny this to the petitioners here? You come to page number annexure J1. Huh? Huh.
Without NIC opening it up, it won't come along. NIC is open it up. And their affidavit also says very clearly saying that in January we requested NIC to do it. NIC did it. Now, but why is that request not being met here?
No, see, come to para 4 of the affidavit filed by the state. NIC has enabled for registration of the said vehicles in January 2024. Thus, the department has made efforts to register the said vehicles. And the vehicles of the petitioner are in compliance of the aforesaid norms. They make a criteria for themselves without getting any instructions from NIC, or rather you have not brought forward anything to say that these are the criteria to be met while seeking for registration under the quota. Is it not? No, now see.
25/7, you know, we've been facing the 25/7 onwards. If I cannot, farmers are now grabbing my neck, because I'm answerable to them. I've shown them this order saying that, see, this is the situation from 2 months, for almost 2 months now. I think the same situation my friend has been saying, I understand it's difficulty, maybe Central Council is not cooperating with him. But you know, there is an order nonetheless.
Kindly come to the order dated 25/7/2024. State government says they will facilitate. And now this order says it is upon the central government to facilitate the registration. Nothing but an obligatory and order. It's a direction to you, but you have to. Where is that denial?
NIC is only a portal again, Manoj. It's central government who has to do it. The central government then takes a call and then.
This is all it's all interlegal.
Because NIC cannot go under the central government saying, no, I cannot do it. It's not a portal. So if NIC today comes and takes a stand saying, I cannot do it, nobody can do it. Central government runs NIC.
That cannot be. Now, what is the notification? Have you got that material? You have got the notification. When will they give the notification? This is every stage of one stage. Every stage you come with a different plea. Is it not? Is it not, Mr. Vaibhav? See, on the last. See, the question is whether such a criteria was fixed. The state government is unaware. They seek a communication from the NIC stating that whether such rules are there or whether such formalities have to be followed for portal. No.
May I just put another perspective to this? In my memo of my lodge to kindly see, I have also produced the notification. My lodge may kindly see the second notification.
Let him produce that notification. We'll pass orders.
I will just point out this one aspect. Because if my lord find way to say that this is not possible, then my lord, I would also say, I'm not concealing anything. I fall under 4 and 5. Now to show 5, Lord. 5 registration, when does it start and when does it end? If my lord were to tell me the second document, this notification dated 27/4. Before that, my lord, my kindly see the first document. This is just a conversion chart to show my lord what category I follow. It is from horsepower to kilowatt. Now, if my lords were to kindly see if it is 55 horsepower, it comes up to 41 kilowatt. Just so that my lords will also see the conversion.
Yes, sir.
Then my lords may kindly come to paragraph to page 6, document number 2. In document number 2, my lord, if my lords were to kindly see, here, my lord, the 7th page, if my lords were to kindly see the central motor vehicle rules, 115 days, applicable with effect from the figures 2024 will then become 2026. Now, my lords were to kindly come back to annexure A in my writ petition. All of mine are 55 HP. If it is 55 HP, then what category do I fall in? If my lords were to kindly see page 21 again. Here, no, my lord, the 2024 becomes 2026. My lords will see in table 2. This 1st April 2024 becomes 2026. Now, my lord, my 6-month period is not even started then. If my lords were to kindly see the category which I fall in, 37 to 56. 37 to 56 is there in table 1 and table 2. It is there for trim 4 and trim 5. Then what is the difficulty for them to register it? Mine is only 41 kilowatt. I fall in this category also.
You follow under this category
Yes,
of,
my lord, both the categories. If it is this category, then 2026. There is no difficulty. I see no problem at all in that.
I can place that notification, will
Please.
not. Is learning council appearing for the respondent 1 and 2, na? 1 and 4. 6, 9, 2, 5. Objections. File
May
objections.
not be objections specifically the notifications because
6, time to get necessary instructions. It's time to get necessary instructions and place the notifications pertaining to the place notification. Does this matter on?
like let it be a little specific on this one request. Let it be specific to say that how they get that criteria. Because then it should not be a situation where again I understand but now NIC is being made a party. Let them say how they get that notification, how they get that criteria. And whether it's communicated to us also not, because I should maybe an internal memo which they may circulate. I have no use for that.
Affidavit. Sorry, an affidavit is filed by the state government on 25/7/2024. By the Commissioner for Transport and Road Safety, stating that the respondent, which respondent is that? Respondent, that the state has written a letter dated 10/1/2024 to the NIC Delhi, Delhi, respondent number 4, for enabling the registration of the vehicles, which are 1, the extract one, para 3 of the affidavit, 1, 2, 3. This court on 25. (25/7, 2024). Noted the submission of the government advocate, additional government advocate, that for vehicles that have been temporarily registered, but since the petitioners have not paid the registration fees and motor vehicle tax, had not come forward and not got the temporary registration done, the application created by the central government, that is in Vahan 4 inverted comma, would not enable the registration of the vehicles of the petitioner, in respect of which the motor vehicle tax has been paid before 36/2023. And on 25/7/2024, Learned Council, appearing for the respondent number 1 union, sought time to secure necessary instruction as to whether NIC could enable the registration of vehicle by making appropriate correction. This court made it clear that since the state government is agreeable to register the vehicles of the petitioners as contemplated under the scheme of the central government, it would be obligatory on part of the central government to facilitate this registration, which is being accepted by the state government. Pursuant to the order passed by this court, the On 27/8, 2024, Learned Counsel appearing for the central government sought time to get necessary information from NIC. Subsequently, by an order dated 12/9/2024, on the submission of the union that NIC, the controlling authority of the portal, was a necessary part. The petitioner was directed to include NIC as respondent number 4. And Learned Counsel so and so was directed to accept notice for NIC. Okay, the matter is listed. Learned Counsel appearing for the NIC submits that there is a notification issued by the central government, by respondent number one, by notification issued pertaining to the criteria for enabling the registration of vehicle. Notification, of course. Whose then we will not be pertaining to the criteria as stated by the state in their affidavit dated 25/7/2020. Learned Counsel seeks time to place on record the notification at request list this matter on
These 2 weeks for quite some time, my lord. It's only been 2 weeks, 2 weeks, 2 weeks.
date, tell the date of the first. First will
We close on.
it be only first. It would be only first because after that there's vacations. Only first October. Mr.
Query has been amended.
Ah.
Restriction has been removed. There is no restriction as such.
Then what happens? It is for their benefit now. ಏನಿದೆ Rule 5? Page 5. Restrictions ಇಲ್ಲಲ್ಲ ಈಗ. ಎಲ್ಲಿ ಓದ್ತಾ ಇದ್ದೀರಾ? Page 2. This is regarding that hospital, bed. State highway, yes. So within a distance of 220 meters from the middle of the state. Or within. ಅದು substitute ಆಯ್ತು ಈಗ. So within a distance of 250 from the middle of the state, middle, ಅರ್ಧ. The distance, the same ಆಯ್ತಲ್ಲ. There is nothing which is changed now. What is that? No, will they come under the city municipal corporation? No. They are not coming under that. ಅವ್ರು ಬರೋದೇ ಇಲ್ಲ ಅವರು. See, this is a hump ಅಂತಾರಲ್ವಾ. City municipal corporation, national highway ಎಲ್ಲ ಅಲ್ಲಿ ಬರೋದೇ ಇಲ್ಲ. It comes outskirts only. ಅಲ್ಲ ಹಂಗೆ ಇರೋದು. ನ್ಯಾಷನಲ್ ಹೈವೇ, ಸ್ಟೇಟ್ ಹೈವೇ ಎಲ್ಲಿ ಬರ್ತದೆ? ಸಿಟಿ ಒಳಗಡೆ ಬರ್ತದ? ಟೌನ್ ಪಂಚಾಯತ್ ಏರಿಯಾ. Which color? That also it doesn't come. Now you have failed to grant him license, huh? CL7 license. On the ground that he has violated the. Now rule. Correct. Now it is 220 meters. Substitution adu. It's not from the date or substitution ಇದೆ. ಅಲ್ಲ ಈಗ ಏನಾಗತ್ತ ಈಗ ಲೈಟ್ ಆಫ್ ದಿಸ್ ರೂಲ್? ಏನ್ ಇನ್ಸ್ಟ್ರಕ್ಷನ್ಸ್ tomorrow only. This memo is filed by the petitioner indicating that respondent number 1 has amended to 5 Excise Act by Gazette notification dated 17/8/2024. The memo is taken on record. The CGT 6 times to get instructions. This matter tomorrow. Please, Madam Shubha.
It is a partnership business having around 3 minutes. Having licensing from CL7 and one CL9. Originally there were 6 partners. One of the partners died.
Correct. That abnormal, that
Abnormality have thinking that see myself, I brought the boy also. Absolutely no abnormality of that kind. He has completed 10 standard. He has signed the document by himself. My submission will be as my lord suggested on the other day, though the order is totally different. The purpose of the partnership is paramount consideration for the partnership, including his interest. Because he is the grandson, only son of the one partner. He should not be put to street is the only consideration for the purpose of putting his name in the partnership. 30% share is created. Before taking it out to the illegality of the order, normally what happens is in the civil court, when a minor guardian has to be according to authority, the court will impose a condition that his interest or his share should not be diverted. The condition can be put here also, his share is 30%. His share. Normally, if it is the civil court will direct that every 6 months you report, etc., etc. Here, that can be protected. Now, with that one, now I think we lost into an order. I also kindly recall that on the earlier occasion I had come before this honorable court. Well, it was mandamus. And in which it was stated that application is not filed, etc., etc., which I have produced all the documents. After the notice was ordered in the earlier, Annexure Q may kindly be seen the page. Annexure Q or Annexure R, page number 71. Dated 16/8/2024. After my lord sir pleased to direct notice in earlier 14/8/2024. Here the order is not with regard to the minor a person boy, according to them, disqualified is included is not the order. Now, entire first page is referring to different respondents. Now, my lord may say, paragraph number 4 may be permitted. ಮುಂದುವರೆದು ಉಲ್ಲೇಖ 7ರ ಮಾನ್ಯ ಜಿಲ್ಲಾಧಿಕಾರಿಗಳು ಕೊಡಗುಜಿಲ್ಲೆ ಮೆಡಿಕಲ್ ಆದೇಶದಲ್ಲಿ ನಿಗದಿತ ಅವಧಿಯೊಳಗೆ ಫಾರ್ಮ್ 8 ಸಲ್ಲಿಸದ ಕಾರಣ ಪುಷ್ಪರಾಜ್ ಅಸೋಸಿಯೇಟ್ಸ್ ಪಾಲುದಾರ ಇವರು 2024 ಸೊ 40,000 ದಂಡ ಆದೇಶಿಸುತ್ತಾರೆ. ನಿಮ್ಮ ಪತ್ರಕ್ಕೆ ಪುಷ್ಪರಾಜ್ ಪಾಲುದಾರಿಕೆ ಅಪರಾಧ ದೇವರ Oh, only the 30% partiality, no. 17A and minus given that the indicate Down syndrome ಇರುವ ಸಂಕಲ್ಪ ಹೆಸರಿಗೆ ವರ್ಗಾವಣೆ ಮಾಡುವ ಸಂಬಂಧ ಮಾನ್ಯ ಆಯುಕ್ತರು ಸೂಕ್ತ ಮಾರ್ಗದಲ್ಲಿ ಕೋರಲಾಗಿದೆ. 17A will not attract because it is not the legal land of an individual licensee. 17A will apply only in case of an individual license who dies and not his last furthermore, ವೇತನ ಅಂಶಗಳ ಹಿನ್ನೆಲೆಯಲ್ಲಿ ನೀವು ಇದುವರೆಗೂ ದಂಡ ಪಾವತಿಸಲು ಬದ್ಧರಾಗಿ ಹಾಗೂ ನಿಯಮಾನುಸಾರ 17A ಅನ್ವಯ ದಂಡದ ವರ್ಗಾವಣೆ ಬಗ್ಗೆ ನೀವು ಯಾವುದೇ ಅರ್ಜಿ ಹಾಕುವುದಿಲ್ಲ. ದಂಡ has been limited. And also scientists the document they have produced having limited the fine amount, though it is not permissible. The deputy commissioner did not conduct any inquiry. He says you pay the fine. Page number 81. 40,000 rupees has been paid. Immediately on the same day within 3 days of the DC notice. This is compounding of the offence and there is no offence. Offence compounding by section 43, 45 apply when an offence under the Excise Act is committed. But they have imposed the fine and they have made the victim say that you are not limited in time. That's also not correct. Nothing is stated about the disqualification under rule 4B of the rules. But permit me to very smart talking about. I had seen some 3, 4 boys like this. A lot of the time you permit me to submit one example of one boy of this kind. He is also SLC to a scribe. Along provision is a 10th standard example. He is also 10th standard. He can't speak. That's all. Only boy I can quote the word was of similar nature. He did his 10th standard. Known person. Then he was put into Shankar Mata for Purohitya learning. Today he is a first class Purohita, assistant Purohita, like that I can say. So like that, this kind of syndrome is not a disqualification under rule 4B. Because if the license is denied on this ground, where should the boy? Father dies after some time. The disqualified on rule 4B may be permitted. Any condition may be imposed to the effect that his share should not be diverted.
Rule 4B, what does it say?
I read. Disqualification, share of Indian government for liquor rules. Otherwise, last page I have submitted on journal statement of 4B. Page number 6, share of Indian.
Sale of Indian in foreign.
Page number 817 is what?
Rule 4B and the rule 17, both you read.
Rule 4B, a person shall be disqualified from submitting an application for renewal of the license under these rules if he has not paid the arrears of any excise dues in the 2. Has not produced valid income tax clearance certificate person. Now, 3. He is holding an office of profit under the state government or the central government. But also see some of the sufficient cases. He is a minor or undischarged insolvents or he is of unsound mind. This Down syndrome or a boy who is sitting here, coming here to the court, is not of an unsound mind. Nor is undischarged insolvent. This has been seen in one of the earlier cases where the husband is a vegetative condition. One who is on the flat condition without able to do anything is not a report of the so long he is not of unsound mind, he is entitled to be licensee. Whereas in this case, the license is not sought for in his individual name also. He remains as a partner along with others, including his father. Perhaps, my lord, they think it's appropriate to protect his further interest to see that.
There has to be a guardian, whatever is said.
I
There has
don't
to
know
be.
what happens is, guardian and guardian.
It cannot-
Also, in this bit only.
Huh? See, if you look at him, he doesn't understand. He is
He
not.
understands, I have talked to him. He
But
can't speak.
we cannot, you cannot.
What happened is,
We are in the interest of him.
interest of him can be protected by directing
This qualification says 4 Bs. If the
unsound mind. So long unsound mind is not there. And there are many disabilities, any kind of, unfortunately,
Now, there is a disability certificate which has been produced.
card also is not.
You protect his interest by taking,
I can only pronounce 226(4). Even without driving me to the civil court or certificate takes long time. 20% disability is there, like our, I'll also kindly see, like our PAN card, card is issued by the concerned department.
card and all, it is
No,
available.
no, it's not PAN card, it's a disability department, sir. 25%, they have passed on order. A valid document. Disability 2003, 25%. Issued as on 26/7/2024 by the concerned department. So your lordship will kindly direct that anyway this is a partnership. We are answerable not only to the excise department, we are answerable to the income tax, etc. Quarterly,
A person of
this
such a,
this 30% will not be diverted from it.
that has to be done internally in the partnership firm, partnership deed, not being placed before the
The
exercise.
partnership deed says so.
Where is the partnership deed? You place all the materials before them.
On one more submission I can make it.
Huh.
This order says that commissioners,
You reconsider and
advisory
pass
someone,
orders.
yes, when I submitted,
So,
reconsideration was not there. Now, my lord, this is the deputy.
he reconsider, look at his, whether he is protected, whether a guardian has been appointed.
Instead of that, excise commissioner is the chief controlling authority.
So there is an appeal provided.
No, no, no. Not from up to 53, I think 53. The complete in charge of the department as a chief controlling authority who can exercise all powers of the deputy commissioner. That is because he is a senior IAS officer. With there's an advisor of that.
No, now that order has been passed by the excise
Can be
commissioner.
passed, may be directed to the close people, excise commissioner, to decide in the next time. Because to avoid because the deputy commissioner of excise, they not understand several aspects with regard to the excise commissioner with his experience has worked in different departments of the
So this
state.
excise commissioner is arrayed as dependent, respondent.
Yes, is number one, number two.
The order now is passed.
He can do it himself.
Section 3 of,
Karnataka Excise Act. He has got all powers.
what is that?
I know, what is your purpose, I know. If their purpose is to make it 50%, and demand twice the annual license fee. That is, that's why Samagala. Namaste. Madam, may permit me to read section 3. The state government may appoint by notification an officer not below the rank of deputy commissioner as excise commissioner for the state of Karnataka, who is subject to the general or special orders of the state government in this year, shall be the chief controlling authority in all matters connected with the administration of the act. The excise commissioner shall exercise all the powers of the deputy commissioner in respect of the act and shall have the control of the but he is entitled in a given case, he has to exercise the powers of the deputy commissioner, the two deputy commissioners in the district. Well, here the as on today, though the act does not speak that, the excise commissioners are of the rank of principal secretary of the state government. Additionally, he will
Now
be
this order is passed by the deputy.
Deputy Commissioner of Excise, who does not mirror, he is not that, it does not refer anything about the disqualification. It only says that I have one page letter, correspondence reference, nothing. This or that, so that with a time bound of 10 days time, Thursdays or any day, you can definitely know that assembly session, etc. is not there, it's free. Because, standing before the honorable court, my interest is the court.
Yes.
It's 4 to 5 of my near people I come across with this picture. The administration of the thing.
Yes. Yes, what is your ground made out now? Disqualification. But your order did not. Yes.
Even High Court doctor can examine and say, he is not Lucha. Section.
It's a disease called Down syndrome. It is called as Down syndrome. It is a type of unsoundness of a child who does not understand. So he may speak, he may not understand the
His
consequences.
interest should be.
In a legal matter, such a person cannot be included as a
He
partner.
may not be liable for prosecution.
That is the reason, this court is. So the reason for not taking such a person into a partnership is for the consequences that.
That much of interest will be protected, he should live.
Should be, but the license on the pretext of getting him impleaded without a guardian is not permitted.
Guardian's mother is there.
Guardian is not it doesn't act as a guardian for this person. He has got it in as an individual.
No, my lord, man. Direct the renewal of the license with a time bound to my lord to
Yeah,
meet.
renewal, there is no renewal now. We continue with the other partners as of now, and not with the, not including this person. We can't include.
What happens if the share is
If you give a partnership deed on basis of the earlier partnership, on death of the one partner, the other partners continue without taking him
one
in.
share, that share
Divided. In this including other matters.
50. I think the petition
Pretext of
this on basis of By the
Eleven.
My lords, I appear for the appellant in this case. My lords, I appear for appellant in this case. Pay for 2 weeks time for complying with the office objections.
Completions.
District Mazdoor Sangha and Bahadur Sahkari Karkhane, Sahkari Karkhane. Memo is filed along with the paper publication for having taken notice by way of paper publication in respect of respondent. Memo is taken on record. The respondent, there is no representation on behalf of the respondent. Notice to respondent number 1 and 2 is held sufficient. Registry to indicate the name of the respondents in the cost list as held sufficient. The steps to be taken in respect of deceased respondent number 2 would not arise as respondent number 2 is a Sangha. Listen, as stated Sutta.
Immediately taken by Korea. The same has been served on the third respondent or 14th.
Somebody who has filed power for respondent number 3.
May I make some? I filed for yesterday, my lords. Kindly granted 2 weeks time, my lord. I'll file my objections. Yesterday I received wakalat, and yesterday itself I filed in the registry, my lord.
Not 2 weeks, my lord.
But he has filed wakalat for respondent number 3.
The objections to the nursing home, the reasons have been briefed.
Registry to put up the same and indicate the name of Mohan Bhatt as the counsel appearing for respondent number 3. Yes, now what? Mohan Bhatt, learned counsel 6 times. That request this
My lord,
matter.
my lords, one submission, my lord. My client has not received with the copy of the writ petition. Learned friend may have one copy on me, my lord, so that I can go through it.
ಇನ್ನೊಂದು copy ಕೊಡಿ.
25-9. Hearing on name, serial number 17, Srimati Gopal.
What happened?
He's not party before the trial court.
So we will delete his name. We will delete his name, right? What is that you want now?
The question is, my lord, may kindly see the annexure. My lord, the agreement which is entered between the petitioner and.
You have to establish
Yes,
that the respondents were working under a contractor.
Yes, ma'am.
Correct. You cannot include them in this petition for the first time when they were not a party. So we will delete his name. You establish on your own. How is he
I'm
necessary?
ready for the final discussion.
Report records, my lord, that they are not accusing any evidence. Show that he was employed to page number 19, my lord. Page number 19, fourth line.
We'll take this on B group itself.
Yes, I'm ready for it.
Raise this matter along with the IS in the preliminary hearing B group. Please.
Literally 17B has not been paid, my lords.
Yes. You file your objection to that application. No, to the objections to I number 3 of 2017.
If it is showing that the objections to IMR, yes, I will take the official report.
Is this in B group? See, if you have to hear that.
Apologies for the sufficiency of the ordering the motion. Then the request will also happen. Because later we came to know that we are rate number 5 euros, para number 11, you can also come to the review application. Now he's working with Kevin K. The request will also to para 11. I further, before 3 lines before the level, I further state that the respondent was working as a sales representative Kevin K. Private Limited having offices at Shampoo and Result. State that the respondent left job at Kevin K. Limited joint sales representative as Uma Consumers and having support services. So, in support of this, on 9/9/2024, when your lordship directed me to index him, at that point of time, we have taken the application form. The lordship permit me, I will submit this document in this application form. We have stated that we are working in the Devin Core and.
Since when?
They pass on this.
See, when if you are working in some other establishment, if you are working, since when you are working?
Page number 5 of the company.
5, huh?
Page number 4, sorry. This is a general application form when you are appointing any person. I also, in that kindly say also, first Chetana Pharma 1970, as a petitioner here. When the Apollo Pharma 14 to 15. Cabin Care Private, which is stated in the paragraph, 18 to 22. Uma Products 24 in that.
This all you should have done at the first round itself. You should, instead of fighting with the court, you should have done all this.
The reason was.
We don't know what was the reason. You were shouting.
Sorry, that the apology.
This is pursuant to the order passed by this court. They have given an application form, no? Pursuant to the order passed by this court directing you to reinstate.
He came to my office on 9/9. Then the usual course, when a new employee comes, we will take this form. And thus, he himself has stated that he is working in so-and-so company.
If he is gainfully employed, he is not entitled for 17. It's his own application.
So own handwriting only.
Yes, Mr. Govindraj. Then we have to recall this order. Which is that I now file, I number 2. Is this court on 20? This court on 2/9/2024 on the application I number 1 of 2024. Directed the petitioner management to comply 17B wages from 12/12/2019. And as the petitioner counsel submitted that the management is ever ready and willing to take the services of the respondent workman to duty. The respondent workman was directed to report to duty on or before 9/9/2024. The petitioner, by way of a memo, files the application submitted by the respondent workman when the petitioner management sought for reinstatement of the petitioner of the respondent and brings to the notice of the court that the respondent has been employed in another establishment, is gainfully employed in another establishment as per the form of application submitted by the respondent before the petitioner. The said memo is filed in support of I number 2 of 2024, filed by the petitioner seeking recalling of the order dated 2/9/2024, contending that the respondent workman is gainfully employed since 2014-15. The memo is taken on record. Learned counsel appearing for the respondent workman seeks time to get necessary instruction. At request, please this matter on Monday. See, otherwise unnecessary, they have to keep on
They
paying.
have not paid so far.
I think we have to recall this order. Like, we'll recall this order, now that we will say it otherwise. It is a liability to them, right? After you have been employed. Allah, see. Correct. Not paid until they have to pay, alva? All ಅಂದ್ರೆ ಈಗ ವೀಕ್ ಆಯ್ತಲ್ಲ ನೆಕ್ಸ್ಟ್ ಮಂಡೇ ಅಂದ್ರೆ ಎಷ್ಟಾಯ್ತು ಇವತ್ತು ಟುಡೇ ಇಸ್ ವೆನಸ್ಡೇ ಗೋವಿಂದ್ ರಾಜ್ equality to all. Yes, of course. Now that he has given his application, ಅವ್ರದೇ ಅಲ್ಲ ಗೊತ್ತಾಗೋದಿಲ್ಲ ಆಗತ್ತೆ ಅವ್ರು ಕೇಳಿ Take granted, madam. Was this stay granted? Right. Central government has not preferred appeal. Only the
How for the case they say, no, the appeal is pending and moving. Even on the last day, the second matter, when this matter was listed, they said we move the appeal. The appeal is moved on the day the matter is listed here. And it's then.
what happened before the
Matter is but even the list matters, matter. It's a court being entertained. The court said that no, it will come up in regular course at best, there's no urgency. If that, that is not being submitted matters. It's submitted on what urgency.
What you have mentioned.
I don't know, the district board of the board, they didn't make a mention in the morning itself, madam.
No, it was
If there was
mentioned at 1:30 also, it was mentioned, and then the court said that we will see the mention. Thereafter at 4:30 also, we mentioned it again, because of the urgency. Thereafter, the matter is posted on 25th now, 25th September it is posted.
this court granted you some time to get an interim order. Is it not?
Yes, but if the
But
matter has
correct,
not
no,
reached
no,
the-
this court cannot say that. How can we say that the matter did not reach?
Immediately after that, some date will be- Because of
Can you know, it's still your office.
they're already
The
covered.
council submission is in the district office of which is still things scribed in the lab. They claim urgency, but ultimately, my lord, the actions don't show for it. So, my lord, here, this is the case, my lord.
Madam, there should be some justification on your part, right?
No,
No, on the ground that there would be an interim order to be granted in your, you said the matter has to be adjourned. Now, there is no interim order,
No,
the,
on when the matter was listed, we had
No,
moved
you
the
just-
matter.
you
What
just-
is now on 25th. Yeah, so after 25th, something.
That's the same
No, you-
submission.
this is how many times this court is adjourning this matter.
No, I am requesting this court because I, on 12th also, for that we had moved, because there was no sitting of the honorable chief justice. the
No,
matter.
no, that cannot be now, we
No,
are
So
not
that
doing.
is why now the court has posted it on 25th.
So you are sure that you will get an interim order on 25th? How many days? Once
No,
the, in the event, you
And the
get,
last. The last on
No,
25th.
that is what-
Otherwise thereafter.
This appeal is. September. More than 3 months, 5 days have passed, we're not even being in a position to move the matter. On one hand, here they claim that there is urgency in the trying to move it, but there is no action being shown.
No, yeah.
And what are they trying to stop? But this is a slow note of payment that I have. It's a damages order. That matters in the Stonegate judgment, not the notice, para 22, that there are orders that will be passed under even section 14B, which is the very same subject matter. It's not the question, here, my lord, it's not a question of social welfare legislation as an employee or somebody. I can make the payments to the.
So what is that prayer we issued now to you? Directing the respondent amendment, not, what is the prayer in your petition?
And that has been challenged, you know.
It is all international workers, right?
Yes.
Yes, ma'am. There's no dispute.
Now, order is available for the They have challenged it for this. Now, in the meanwhile, this judgment has come. So thereafter.
No, but whether they are entitled for this in light of the judgment now passed by this court, whether they would, the petitioner is again liable to pay that amount.
As of now, there is a stay of that order.
Ah.
The 14B order, there is a stay of that order.
The provision itself doesn't exist as of today.
There is a stay on that order, they are not recovering that amount also.
But that can't be the reason.
We'll make it clear. We'll make it clear on 25th. If you don't produce any interim order, we are going to dispose of this matter. Learned counsel appearing for the respondent submits that against the order passed by this court in WP 18486 of 2012 and connected writ petition. The respondent authority have preferred this appeal, and the respondents are seeking for an interim relief in the said petition and seeks for a shock accommodation. The petitioners place reliance on the decision of this court in WP 18486 of 2012 contained that the petitioners are squarely covered by the decision of this court and the levy of damages. Levy of damages by the respondent needs to be quashed in light of the order passed by this court in the above referred petition. As a final chance, list this matter on 25th. Yes, I thought 26th, on 26th.
Will be create with number.
What is this IA? Though they were not. What is your locus standi to file that writ petition now before this court? Now, how are you challenging that order which has been already granted in their favor? Were you also what is your locus standi?
Applicant for allotment of the site notified by the APMC. I also applied Miller. The sites will have to be granted on the basis of the seniority. The seniority list requirements are not. Though I am senior, many of the persons who are junior to me have been allotted the sites. In fact, I had paid for a particular site and that was granted to my junior who is serial number 50, I am serial number 72, according to the decision of this honorable court. If
Now, who appears for the impleading applicants?
the road is not a product,
No, we'll issue notice to them. Let them.
objection. side. They're saying that it's not part. Now, they want to increase the applicants of notification, other two notifications, 69, 2021.
Not pertaining to the notification under which they have.
They are not even challenged these two notifications also.
You have filed your objections to the. Yes, you file your objections to the application. Application. Who has to file objections? You have filed the objections, yes, there is that.
Sorry for the interruption. Right, it's saying that I have challenged the notification for application. Your lordship, my kindly see, I have challenged annexure A, allotment of sites. Annexure A is the allotment of sites that I have challenged, not the notification calling for the applications.
The allotment of sites. Allotment of site is pursuant to which notification?
Pursuant to annexure B
Which
notification.
is the notification annexure be dated?
Annexure B dated 2/21, my lord. Annexure B.
2021. 2021.
Annexure B. Wherein then applications were called for.
Correct. Now the impleading applicants whom you sought to implead, they are allottees pursuant to which notification?
This notification 2021 only. This would be clear from annexure C because in the senior is prepared pursuant to the applications received under 2021 annexure B. Your lordship will read kindly see page number 43. So and so prakara Samidiya license ಪಡೆದು ವ್ಯವಹರಿಸುವ 42 is the annexure C, my lord.
So in annexure A,
Yeah.
this is pertaining to the notification dated 2/2/2021. Where
Yes.
does it find?
It will be clear from annexure C, my lord.
Annexure A nalli torsi, where is that
For-
reference to the notification?
Yes, yeah, I will show you.
First page alline irutte.
ಅಲ್ಲಿ 27 ಅಂತ ಹಾಕಿದ್ದಾರೆ
ಮತ್ತೆ
2021 ಅಲ್ಲ ಲೆಟರ್ ಅಷ್ಟೇನೆ
where is that?
155 ಸೈಟ್ಗಳನ್ನ ಕಾನ್ಫರ್ ಮಾಡಿದರೆ
First ನೀವು substantiate ಮಾಡಬೇಕು. This respondents, the impleading applicants whom you are proposing to implead, they were under the very notification under which you were allotted sites. Where is that?
annexure C.
Annexure A you are challenged with.
Yes, Lord.
Annexure A is pertaining to whom?
Pertaining to the
Yes,
merchants, traders, dalals, commission agents who are
correct. Pertaining annexure A is issued by the third respondent.
allotting the sites pursuant to the applications received under annexure B.
And the notification is dated 22/7, Mr. Counsel.
So this is going to be the allotment order.
Right. What is your order? Under which notification you are claiming?
The same notification, this notification I have challenged annexure A. In this notification, I have also allotted site. My respective submission is, I have sought for a particular site that has not been given to me and it has been given to juniors, several juniors of mine. According to decision of this honorable court, if an application is made under this act, it should be considered with reference to the application which has been made. In this case, it has not been so. The matter is covered by the decision of this honorable court. I have produced as annexure U. Annexure U. Annexure U, along with my rejoinder to the statement of objections filed by the state mayor. But last my kindly take my rejoinder. First filed on 22/6/24. Annexure U is at page number 31.
Annexure U na Q na?
Annexure U Swami, 31. ನಾನು rejoinder ಹಾಕಿದ್ದೇನೆ ಅದರಲ್ಲಿ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದ್ದೇನೆ ಜಡ್ಜ್ಮೆಂಟ್. rejoinder ಸ್ಟೇಟ್ ನವರು ಹಾಕಿದ್ರು ಸ್ಟೇಟ್ ನವರು ಕೊಟ್ಟಿದ್ದೇನೆ ನಾನು rejoinder.
Andre,
ಅವ್ರಿಗೂ ಕೊಡಿ ಅಂತ ಕೊಡ್ತೀವಿ
you
ಸ್ವಾಮಿ.
have to give all the respondents.
Because respondents ಗೆ ಕೊಡೋದಿಲ್ಲ statement of
Okay.
objection ಯಾರು ಹಾಕಿದ್ರು ಅವರು
Why are you making them as a party then? ಅವ್ರನ್ನ ಪಾರ್ಟಿನೇ ಮಾಡ್ಬೇಡಿ. ಅವ್ರು ಕೊಡೋದ್ ಬೇಡ ಅಂದ್ರೆ. What is submission, Mr. Counsel?
Your Lordship may kindly see paragraph number 4. ಇದರಲ್ಲೂ ಅಷ್ಟೇ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿದ್ರು ಅವರು ಕೊಡದೆ ಬೇರೆ ಯಾರಿಗೋ ಕೊಟ್ಟಿದ್ದಾರೆ. In contract, the limit for the third respondent, the petitioner has given multiple preferences, so and so. They further submit so and so. Next, sixth paragraph, the petitioner has submitted an application indicating 30 sites as similarly, the third respondent ಅವರು ಎಲ್ಲ ಕೊಟ್ಟರು. Then another paragraph number 6. Paragraph number 6.
Now see, he's seeking to include those allottees who were given the site which is.
On site apart from the upgrade slot. Already included these respondents. Already identified. What my learned friend now wants to increase is the use of vestible vendors for the allotted sites in important cases. Yes, nothing to do with this.
That is why this court asked you, which is that notification you are before this court.
Annex seniority list ಮಾಡಿದ್ದಾರೆ pursuant to the application.
Why do you want to include the respondents as party to the proceedings when they were not under the very notification under which you were allotted sites? That is the question.
My respective submission is.
Mr. Counsel, Annexure A is the order which you are challenging. Just show from the Annexure A, where is the notification indicated? And whether the respondents are pertaining to the very notification. You are sought for 5 sites, it seems. Alva, you were granted 4 sites, 1 site you were not.
ಒಂದೊಂದೇ site ಅಲ್ಲಿ ನಾವು ಕೇಳಿ ನಾವು 5 site.
So.
The case is that apart from these 5 sites that given the site, these 5
Has been allotted to the other.
Juniors.
Who are made as party in this proceeding.
They are already
So the sites which they had sought,
Yes.
that allotted to the respondents, other respondents.
they are already.
ನಾನು ಮಾಡಿದ್ದೀನಿ ಸರ್ government
ಯಾಕೆ ಈ other respondents ಯಾಕೆ ಪಾರ್ಟಿ ಮಾಡ್ಬೇಕು?
ಈಗ 36 ಜನಕ್ಕೆ they are not entitled to ಅವ್ರಿಗೆಲ್ಲ A ಬ್ಲಾಕ್ ಅಲ್ಲೆಲ್ಲ ಕೊಟ್ಟಿದ್ದಾರೆ.
How is that your grievance? ಅವರು another notification ನಲ್ಲಿ ಬಂದಿದ್ದಾರೆ.
Another notification ಇಲ್ಲ under the
There is
same
that.
notification.
Have to just.
ಅದನ್ನ ನೋಡಿಸ್ಕೊಂಡು seniority explain ಮಾಡಿದ್ದಾರೆ. ಈ 36 ಜನ ಇದ್ದಾರೆ.
Now, why you want to impede who are not even concerned to this notification?
My question is to be allowed on the basis of the technical design of the application.
What type of submission is this, Mr.
ಏನು ಅಂದ್ರೆ ಸ್ವಾಮಿ A ಬ್ಲಾಕ್ ಅಲ್ಲಿ ಇಲ್ಲ A ಬ್ಲಾಕ್ ಅಲ್ಲಿ ಸಿಕ್ಕತ್ತೆ 36 ಜನಕ್ಕೆ ಕ್ಯಾನ್ಸಲ್ ಆದ್ರೆ ಅವನು
What is this, Mr. Counsel? What type of submission? What do you want to do of this application? Tell us. After arguing the matter for some time, then a counsel for the petitioner does not intend to press I number 3 of 2022. And accordingly, I 3 of 2022 is dismissed as not pressed. Yes. So that has to be allowed?
ಅದನ್ನು ಬೇಡ ಅಂತ ಹೇಳಿ ಲಾಸ್ಟ್ ಟೈಮ್ ಬೇಕಾಗಿಲ್ಲ ಅವರು ಪಾರ್ಟಿ ಬಿಕಾಸ್ ನನಗೆ
That also you don't want to press?
ಸರ್ವಾಗಿಲ್ಲ ಅಂತ
ಈಗ ಸರ್ವ್ ಆಗಿದಾರಲ್ವಾ? They have been served, right?
Or need has not been served according to the office report. Therefore, I have made the application.
Correct.
ನಾನು ಯಾರ ಸೈಡ್ ಸರಿ ಮಾಡ್ತಾ ಇದ್ದೀನಿ ಇದು ಅವ್ರು ಆಲ್ರೆಡಿ ಪಾರ್ಟಿ ಇದ್ದಾರೆ. Therefore, distance with the notice will be distance with.
I1 of 2024 seeking paper publication by the petitioner is dismissed as not pressed as requested by the petitioner. Stop. Respondent number 8. Memo Haki. Learned counsel for the petitioner seeks to dispense notice to respondent number 8. Memo is taken on record. Notice to respondent number 8 is dispensed with at risk of the petitioner. Next, Merits fellow. Ready for the, same sites which they are also.
ಇದರಲ್ಲಿ 10 ಜನ petitioners ಇದ್ದಾರೆ ಮಾಡಿದಾಗ 7 withdraw ಮಾಡ್ಕೊಬೋದು.
Discussion preliminary hearing B group ನಲ್ಲಿ ಬರ್ಲಿ. Please this matter in preliminary hearing B group.
Getting order, serial number 21.
Getting order Saturday. This was matter on 21st. Yes, 21st.
Much obliged.
Madam, on 21st for dictation.
Please, my lords, much obliged.
Sample panel should be. Monday. Monday.
Number 24.
This is pertaining to what? Forfeiture.
Cannot be forfeited.
Yes. Saturday, na? Yes, government, SCGP, government, where is AAG? Monday, I mean Saturday. Saturday. After.
25. Very lyrics number 25.
Yes, Mr. Bhatt. You are ready in this matter, right? Afternoon, after the further hearing matters. Or if you come at 2:30, we'll take it up at 2:30. Pass on.
Number 26, adjourn. Serial number 27.
Mr. Ramchandra, what happened to the mediation report? We'll pass over now. Just talk now. Pass over. Well, now she is unaware about it. So you tell it on the at 2:30. Yes. You are ready. Narayan Bhatt. Please different Narayan Bhatt. Huh? No, you are the Ramanya Bhatt, very Narayan Bhatt. Who appears? M. Narayan Bhatt. The password.
Number 29. Narasimha Swami.
Yes, Mr. Miss. What happened? Where is that? No, we have not asked you anything. We asked you what is the procedure? What is the position now? What happened to the DCVC committee? What order has been passed on the caste certificate? You were only directed to get instruction. What is that? Right, we have not made the DCVC as a party here. So you have to get necessary instructions. This is only to the limited extent to know what happened to the caste certificate. So you just ask and find out. At the request of SCGP, list this matter on. Yes. We are still continuing the list. Yes, at the request of the petitioner counsel, list this matter week after next. Next in Sidramaya.
Number 30. VV Sidramaya. Serial number 31. V. Bhargavji.
Ready? The petitioner, where is the petitioner? What is this rectification? non-amendment. He has to carry out so many things. Then why was it again listed here? Ah. Let him rectify this office objection. No representation on behalf of the petitioner. Unit counsel for the respondent is present. The petitioner needs to rectify the office objection raised by the registrar. A week's time is granted to do the need. Is this matter on 25? Yes. 26.
Number 32. BC Sitaram Rao.
Yes, Mr. Sitaram Rao. Password.
Number 33. Sri Mohan Bhatt.
Yes, Mr. Mohan. Okay. 2015 ಎಲ್ಲ time ಕೊಡ್ತಾ ಇಲ್ಲ. ಇದು ಲಾಸ್ಟ್ ಡೇಟ್ ದಿಂದ ಈ ಡೇಟ್ ಗೆ ಬಂದಿದೆ ಅಲ್ಲ. Petitioner counsel 6 times list this matter next week.
Number 34. Srimati Padmaya Suttur.
What is this? How much?
3 months ago, audit my lord, we will implement 27.5 cents.
ಎಷ್ಟು ಸೆಂಟ್ಸ್ ಅಂದ್ರೆ ಎಷ್ಟು ಬರುತ್ತೆ? ಗುಂಟಾನಲ್ಲಿ
2.5 cents.
ಅಂದ್ರೆ half 10 ಗುಂಟಾಸ್. 10 ಗುಂಟಾಸ್ ಅಂದ್ರೆ
11 guntas.
ಹಾ
11 guntas equals to 27.5 cents. As per they have as per their own statement below the 5,600 rupees per cents. The popular has awarded global compensation of rupees 15 lakhs.
What basis it has been awarded 15 lakhs?
Nothing was basis. We also kindly see the in page number 42.
Let she come in the afternoon. We'll take it up in the afternoon. Yes, first.
Milord, may I make a mention, Milord?
Sir, senior counsel.
Mr. Serial number 54 was mentioned to your lordships in God poses today. I talked to Madam Pramila, madam.
Yes,
Madam
yes.
says she is also not, she did not ask for this today's date.
Ah.
I don't know whether it will reach today. If your lordship could have it on Monday, my lord, I talked to Mr. Madam Pramila, she had agreed. It could be had on Monday, my lord.
Allah, see, senior counsel mentions that he has talked to your senior counsel. No, Antira.
I had just now talked. How does he say like this?
I can break it into like
Madam Pramila is here.
Madam.
Yes, my
Your
lord, my
instructing counsel.
he just called me and said he can have it on Monday. I was wondering whether it would reach today because serial number 54. After ನೀವು ತಾವು 2:15 ಅಂತ ಹಾಕೊಂಡೆ ಕನ್ವೀನಿಯಂಟ್ ಆಗುತ್ತೆ. So that we'll be sure that it will reach.
It was moved by your instructing
counsel. Yes, my lord. Because the parties were insisting, I said move the advocate on record. I had no objection, but I do not know whether it will reach. Miss Kasturi, senior counsel, called me and said, would it be possible? Can we have it on Monday? If convenience of both the advocates are more important.
Yes. Release this matter on 23rd at 2:30.
Grateful to you.
In my matters.
Yes, interim order granted earlier is extended. Allah, senior counsel is here, Mr. Counsel. What type of submission is this? Your senior counsel, not theirs, yours. Madam is here. She has said that she.
Myself and Madam Pramila, I know her
have to
for 50 years.
Some you have to maintain in the court. Last Chandra, interim order granted earlier is extended to the next date of hearing. Serial number 54.3, 54.4, 54.5. Yes.
Much obliged.
In number. Yes.
I am thankful to my friend.
Madam Pramila, madam.
Yes, my lord.
Your instruction counsel says no, the matter should not be adjourned. So please
No, my lord, I have been insisting. I never wanted adjournment today also. But my
No.
letter said that I am agreeing.
Yes, yes. So we'll have it on Monday
Yes,
at 2:30.
great. Yes, my lord. Yes, my lord.
Very well. Thank you, my lord.
Yes.
Madam, serial number 33 ಅರ್ಜನ್ ಆಯ್ತಾ? ಕೋರ್ಟ್ ಆಫೀಸರ್, ಇದು ಸೀರಿಯಲ್ ನಂಬರ್ 33 ಅರ್ಜನ್ ಆಗಿದೆ. The code officer, sir. Serial number 33 and sir.
Next week.
Next week, sir.
Okay.
Thank you, sir.
Further reading serial number 60, Srimati Sudha B.
You've completed your just now. Really?
Up to the honorable Indian bench disposed of the appeal. Is the appeal is observation. Thus, I am entitled to work out my remedy in a competent court or authority. The competent court in the normal sense is maintained in court. But in section 68 of the Karnataka say that the matter which has to be decided by the authority is the bar of court. So, only remedy available for me was to submit a petition to the Excise Commission. Involving, one is also I had argued there. Section 3 of the Karnataka Excise Act, as a chief controlling authority. The Excise Commissioner even till today has not done anything on my application. Though it is dispatched to immediately after the order was made by the honorable division bench. Now, my lord, this great petition pertains to when the matter stood thus that the application of pending before the Excise Commission. The Deputy Commissioner of Excise, without considering my application, renewed the license. That is, for a first intervention is concerned. In the second intervention, during the pendency of this intervention, and unmindful of the fact that I have made a claim and the matter is to be decided by the honorable court, the location of the shop is also changed, considering this application. Further, one sentence could have moved as further development for the authorities to consider this law.
The installment number for K. Manjunath is running the business as a transferee of the same from Savita. Savita is not a party to it, it is a party to other. Because from the husband, this is Savita to the other. All along, my lord, commitment to have, the name of the business was Savita Wine Shop. I have no difficulty over there. After the improved order has been made, for the purpose of judicial note to be taken by the honorable court, after the writ appeal has been paid and after this, or improved order has been made, renewing the license and changing the location, the name of the business is changed as Pink Berry in the place of Savita Wine Shop. The Pink Berry, my student submission is that my lord. It's a chain of tier 2 licenses. At least 200, 50, 60 licenses are in the Bangalore city are running the name trade name as Pink Berry. That is run by one Shiva Kumar. Ravi Kumar. The Ravi Kumar, just not name boards have taken Ravi Kumar. Several licenses are there of Ravi Kumar. And this license, who standing in the name of Manjunath, is also having the same feedback for the purpose because to bring it to your lordship's notice that with the eyes quite open by the authority, this offences are committed. So in fact that the license has also been illegally transferred without a transfer application made to her. Means I have a benefit of the investigation report by the Central Crime Bureau branch of Bangalore City as directed by the Honorable Court. The Excise Commissioner has obtained a copy of the inquiry report placed before this Honorable Court by making an application by directing to the Honorable Judge. The application has been the entire set of investigation report. I have also taken and I have placed before the Honorable Court also. Somehow I am not able to make the Honorable Court. The Honorable Single State just found it before passing the earlier order. The Honorable Legal did not notice it. I had discussed that. Why now can this?
We cannot say anything about it.
No, I did not notice it. That's that thing. My response submission to the Honorable Court is that it is a part of the records of this Honorable Court in the that has to be seen. It will establish the fraud. The inspector, whoever is the officer, senior officer of the Central Crime Bureau, in short, it's called a CCB, which is entrusted the job of important cases, has thoroughly investigated into the matter. It has no direction to lodge a complaint under the FIR. Just given the report. Report establishes the fraud.
You are challenging the from initial stage from the license being transferred from
License being transferred is over up to the determination.
from Savita to Manjunath.
Savita, no, from my husband to Savita. Savita to Manjunath. That was the earlier.
That has attained.
That has attained. The Honorable Indian then gave me the report to approach the authority. I approached the authority. When my application is pending before the authority, the Deputy Commissioner of Excise has renewed the license. That is in this first expedition. Second expedition is apart from renewing the license, without consideration in the fact that matter is reached out by the Honorable Court. Willingly, the location of the license is not changed. Subsequently, these are the two matters, madam. I am content, in spite of all this after. If the Exchange Commission calls both of us, there is nothing wrong with for the other side also to participate in the proceeding because what is established. Unfortunately, I have not been able to because of the direction I have not been able to lodge the complaint by myself, nor the Exchange Commissioner or the Deputy Commissioner said I was not able to. In the form of an FIR. They should have
clear the dispute within the party. Yes. So the solution is there. Is the apart from argument. The Excise Commissioner may answer to the Honorable Court why he is silent on my application. It is not that the Excise Commissioner is just sitting and going to the office. Every Tuesday, every Thursday, he has the appeals. Every Thursday, he has other petitions also. Apart from this original petition, there are other original petitions like the granting of label on the excise label of the bottles, etc., etc.
Now, who are the petitioners here? Who are the petitioners? How are they related?
Petitioners are, the first petitioner is the wife of the deceased original licensee.
Jaishankar.
Jaishankar.
So, Jaishankar, way back
Yes.
in the year 1997,
97, he died on 9 to 1997.
he transferred this license to
On
Sabita.
30th of June.
At that point of time, you have not challenged.
No, we have to have the delay before the order was there. After considering that, that's the important aspect of it. That could be a right way. After considering the fact that we have come to the honorable court almost 20 years later, finding suspicion, the honorable court has directed the investigation by CCTV police. I produced the copy of that. So that is how delay has been answered. How I lost before the honorable division is deep that I lost.
What happens now in light of the order passed by the
Division bench order.
What happened?
Then it will- my application is pending before the commission. This developments have taken place. I have questioned the subsequent development. First development, renewal of the license in favor of Manjunath. Second development is switching the location to frustrate the entire case. In so far as the delay aspect is concerned, my lord.
Pursuant to this, what happened? Pursuant to the order passed in the writ appeal, what happened?
I made a petition to the commissioner. The commissioner did not.
That is
do
pending, that is pending
That is
consideration.
pending. The commissioner is there because of the loss of so much of time. But the setting aside the order of renewal or shifting may not have very much importance. Once the commissioner let him decide, let him say that we are wrong. Let him say that I am not going to lodge a complaint in spite of having the CCTV report. If my lord CCTV report has seen 200-page report they have made.
That has now attained, rather it has come to an abeyance stage. It has rather come to an abeyance stage to this court. Now it is pending consideration, right? Let the commissioner decide. And now what is that you are before this court? The granting of license in favor of the renewal in favor. Correct, renewal in favor of the respondent. Now, if the matter is being considered by the commissioner, in so far as the inquiry to be conducted or initiate any action.
Until then, the license, I will not come in the way of.
So that has to be continued. Then.
That's all. If the commissioner at least for 4 weeks time or 4 weeks, whatever.
Whether you have challenged the inaction on part of the commissioner in not come.
No, I have, because I have challenged the action of the authority.
Still is one thing.
Because at that particular time, I made it immediately after the direction of the Honorable Indian Bench, I went to the Excise Commission. But without the input dry on that, the authorities have the deputy commissioner reduced the license. If I say that I have mentioned in the pleadings that my application is pending consideration before the Excise Commissioner. But in a hurried manner, that the authorities have the.
Now, they are already running this.
They are running the shop. The running of the shop on the day 1, 30th of June 2020,
97.
97. Is only wrong. They have the benefit of all these years. Cannot be brought back. I am not entitled for either free profit or whatever it is. I will get the rest. Even other proposal was also made to the authority. Now the government has banned the granting of license. As a special case, having found that fraud has taken place.
My license, we are denied with the livelihood of getting a license. In the meanwhile, other side is also benefited. Let them even take the sanction of the government and give me the license. I am not jealous about the other party also. Because my application is I have read it, but all the pleadings are mentioned in my this petition.
Where's the question of quashing the order passed now by the respondent number 4? Your inquiry or whatever petition you have filed?
This issue, let me keep it pending. Direct the commissioner to come out with the. It is pending.
But then that is not the prayer you have sought in this petition now. Now, is that a prayer?
My submission is that,
That they will take. We will ask the CGP as to what has happened to that. Yes, what has happened to that?
When we put up another 2 weeks, I'll go to the commissioner. Then I will say that in
Yes. What you say about this? Now they have not sought that prayer in this petition.
Because it's not a person authority, it says there's no authority. So waiting for the matter will not arise. Some of the observations made by the division finally sees the matter, but that's your lots of right here. So, as the transfer is concerned, division bench says only liberty reserved was they claim that there is a report at that time, the one initially is not other actions. They say that they have gone back to excess commission in the division bench as well. So ultimately it's going round and round. It's nothing but an endless story. End of months, it's eating the tail of another snake, and similarly the other snake's head is some of this beings. As you lots of said, there's no question of challenging the review. It's now subject to control. First, like I said, this is a repetition which we barred by the principles of issue as well. Page number 120, go your lots of anything.
120?
120.
The first writ petition.
Yes, the number 1978 of 20.
Yes.
Because the order starts at page number 106.
Yes.
There are certain contents which I take your lots of the recreated, but your lots of anything, create 120. Para 16. At the outset, it is necessary to know that the question, the repetition is given by CCTV. The very nature, very identity of action, the original license, the petitions technically they are spent. Father respectively, the rest of 5 and 60. Nation can be claimed that the petition is different and received itself. Date of death of the nation is also disputed. So, God, fabrication of record documents is a complex aspect. Thus, as right, taken over by the non-secret. This question of fact cannot be confirmed. The denies is on the entire claim is being made. Then your logic like I take a page number 126. First, I read from para 17. This is where what has been observed. Para 17. The next issue that arises for consideration is the direction section to learn CH for conducting an inquiry into the matter of procedure by a police officer. Further directions to the Department of Excise Commission of Excise to conduct inquiry based on the report submitted by resident. Further actions as subsequent block. Was here. But much has been said about the report submitted by PCB. And what was considered by the division bench was exercise on the part of the learned agent, the coordinate bench, in directing to inquiry by the police and the consequential direction by the final orders. On our repeated request and repeated queries to the learned senior councils also, appearing to the repetitions as well as to the learned additional advocate. No provision under the Act or rules are brought over notice, justifying the inquiry by the Commissioner of Excise Department of Excise into the complex issue of the nature noted above. The learned senior counsel of learned advocate made attempts to refer to section 3035 and 50 of the Excise Act. We are not inclined to accept the same, as the said provisions do not cover the matter of the station to be investigated by the authorities under the 1965 Act. brings down the curtain on all these issues. And then having extracted it, you not expect any third paragraph of the reading. As a conclusion of the opposite motion, we make clear that there are no provisions which enables the authorities to undertake inquiry investigation, particularly with regard to the aspect of fraud and fabrication of documents and the identity of the persons. Investigation inquiry conducted under section 35 are in respect of offences under sections 33, 34, 35, 38, 38, which are everything chapter 7 of the Act. The senior counsel fairly submits that inquiry of investigation in the nature of the matter required in the present case can be undertaken upon filing of the complaint to the jurisdictional police. Thus, there is no qualms about the fact that Excise Act and the rules do not contemplate any provisions to deal with this situation on that. Where's any question of going back? And then you are also have a look at page number 132. Because I just read page 129, what I just writes at paragraph number 20. Referring to Angeles case, para 20. In view of the opposite provision of the enunciated by the apex court, and also in the absence of any specific provision of the Excise Act, you have the considered view that the directions issued by the improved order to the Commissioner Excise Department to conduct an inquiry, that on the basis of the report submitted by the asset comes from police by virtue of the order dated so passed into objective number so cannot be sustained and as such the inquiry will be run without jurisdiction. The para 21 deals with the question of delay. Approximately, can you take page number 122? Because I read from the last sentence in page number 131. On 4 lines from the bottom. Current senior counsel appearing for the petitions famously commented that ignorance and economic relations of the petitions cannot be lost sight of. Besides, he also referenced in the order dated 26. Passed to the learned senior judge having been inquired by the competent officer. Into the matter just to express covering the delay in the repetition. Our considered view, the sense sufficiency cannot be accepted. And then, what is my take page number 134? Because I read about 7 lines from the bottom. The fact remains that's how the sentence starts. The fact remains that the petitioners were aware of the husband and father respectively carrying on the business of legal respective and feeling and submission regarding the equivalence of the same and economic condition for 21 years cannot at any stage of imagination be accepted as a justified explanation or reason. But then nothing else is and then page number 138, para 28. We are unable to accept the submission and view of the fact that narrated above, more particularly knowledge of the petitions regarding legal business carried out by the Jaishankar as exposed by the ABC. The securities also. We are also not inclined to accept the submission of the senior counsel that the order passed by the senior judge on 26-21 as order controlling the petition. Thus, even on the ground of India and latches, petition would not have been entertained. Then, having thus found, it is clarified that authorities under the Act 1965 and the rules made therein be entitled to initiate the inquiry with regard to violation of the provisions contained thereof in respect of transfer of license. This order will also not foreclose legal remedy or options if any available to the petitioners through the competent court of law, forum or authority, and the petitioners are at liberty to seek such remedy as may be permissible by the law. The observations and reasonings made in this order work with regard to sustained interpretation for the past all contexts will be available maybe are yet to. The reason why I read this is the next paragraph is important. For the opposite reasons and analysis, the observations in the case are allowed. Order dated so and so passed in the repetition side. Any consequent orders passed by the excise authorities pursuant to the directions of the repetition will have no effect and cannot be reviewed. Because with the dependency of the appeal, the orders were sought to be passed based on the directions of the currency again, according to the rules of the legal bench. Legal bench passed an improper order saying that this is not an order in substance, it's an interdepartmental communication. But since this was canvassed during the course of the argument, the division bench clarified that any subsequent orders which come after the signature orders observe no consequence. Now, what was very clearly observed was no question of holding, exercising any jurisdiction under the Act or the rules of the nature of a transfer of license allegations is contained. Now, what this person does, not like any have a look at page number 141. Which was free, which is presently the petition which they claim is filed.
41 is the.
Because this is the petition which they have filed before the excise commissioner pursuant to the liberty granted is their case.
But according to you, the order of the division bench does not indicate him to approach the commissioner. It's
Certainly. There is in no uncertain terms that the authorities have no jurisdiction under the act and rules deal with the situation of the kind. Now, what is my going to take page 144?
One?
144.
Yes.
Yes. Direct the Deputy Commissioner of Excise, Bangalore to report the crime to jurisdiction police or CCP for offences committed mentioned on the Indian Penal Code as well as Excise Act and retrieve the books. Others the order dated 26/1997. Now, what is my kindly see page 34?
Yes.
Page 34 is the prayer made in the earlier petition by the very same petitioners.
Yes.
Hearing of sessionally appropriate legal direction, quashing the order dated 26/1997. But when this order was subject matter of challenging the petition, and the division bench says that this will not be on account of intent taxes. And also for the reason that there is no question of excise authorities exercising any power to meet the situation of the kind of the excise act. He again goes back to the very same authority. That's the reason why I said, it's like an endless story. You can't keep on making rounds and rounds and rounds. Now, said this, you're not simply going to see what's the position of all this regard. But instead, with the issue of all the action has come and issue has come. So I refer to one Kumar Jain's case, 2005 volume 1 SSC case 78. Numbers. What's my idea? 998 there is a distinction between issue as to and treasury data.
So para 18 of the.
Circular question as far as balancing might be part of it said. Also get attracted in the same person also fighting the subsequent. Find the present case, which are by state Supreme Court said. Find the present case, the person that opened the very question which finally concluded. Namely, whether respondent of the was or not with the suit land. Further erroneously entered into the court by the put on in an appeal of political documents surrendered at the president value. How can this question about registration with the CPA file? Declaring in both conditions case, important consideration of public policy with the decision comes by courts of conflict distinction. If filed unless they are modified difference by the appellate authority. Another principle is that no one should be made with the same kind of indication twice over because such a process would be brought into the consideration of fair trade justice. Further, it was said that the law on reciprocated estoppel is well established in India. There are ample authoritative pronouncements from various courts to suspect as the view of reciprocated or technical based on public policy. In order to put an end to litigation, it is however different. If an issue which has been decided in an earlier litigation again arises for litigation between the same parties and for the cause of action, or where there is a continuous cause of action, the parties may not be bound by the litigation made earlier if in the meanwhile law has changed or has been by a higher forum. But that situation does not exist here. The existence of constructive adjudicator apply with full force. The subsequent stage of the same we refer to order 47 that the court review is not permissible on this ground. Then 47 is referred to. Then your lordship may kindly come to paragraph number 59. There is a distinction between issue estoppel and reciprocata. Today also student. The reciprocata demands a court for exercising its jurisdiction to determine the risk plus the right minority between the parties. Whereas the doctrine of issue estoppel is invoked against the party. Such an issue is decided against him, who would be estopped from raising the same in the later proceedings. Doctrine of reciprocata creates a different kind of estoppel, that is estoppel by record. In the case of this nature, however, doctrine of issue estoppel also a cause of action estoppel may arise. Today, not before head. Cause of action estoppel is that which prevents a party to an action asserting or denying as against the other party the existence of a particular cause of action, non-existence or existence of which has been determined by the court of public jurisdiction in a previous litigation between the same parties. The cause of action was determined to exist, that is, the judgment was given on it, it is said to be merged with the judgment, it was determined not to exist, unsuccessful treaty can no longer assert, and it does, it is estopped. But then next part is very important. Second dicta is followed in Barber versus Staffordshire County Council. Cause of action estoppel arises wherein two different proceedings identical issues arise, in which event the latter proceedings between the same parties shall be dealt with similarly as was done in the previous proceedings. Such an event, the bar is absolute in relation to all the points decided, save and except the allegations of fraud. Now, all these allegations have already been considered. Now, Narsingh Rao's case, I did not read the relevant portion. Narsingh Rao's case, if you are to recollect, dealt with the issue of million pages, where the fraud also. It says, from the date on which you have realized that there is a fraud, you have to come to the court with a reasonable time. They set up the plea of fraud. Then, what happened during the course of the proceedings, which is part of the order? They had initiated everything saying that Jayashankar had died. The court specifically asked, having taken a plea that Jayashankar was running this business. Then those documents were produced before the trial bench to show that they had made the pleadings in the 1997 itself, when they initiated MBC proceedings, that Jayashankar was running a business with excise license. So, having considered, the division bench has already taken a view to this extent. Now, the second thing, which I just wanted to mention is plantation was I just gave that judgment also. Please refer one paragraph notes in part 26. That will draw the principles of establishment.
Yes.
Setting law that the principles of establishment are for public courts and justice. Doctrine of reciprocata is often treated as a branch of law estoppel. Though these two doctrines differ in some essential features, of reciprocata prevents the parties to from litigating the same question over and over again. Even though the interpretation may even be demonstrated wrong, in the proceedings of finality, parties are bound by the judgment and the estoppel proceeding. They cannot litigate again on the same course of action, nor can they litigate any issue which was necessary for the decision in the earlier litigation. These two aspects are cause of action estoppel and issue estoppel. These two terms are of common origin. Again, once an issue has been decided finally determined, parties cannot subsequently the same issue advance arguments or adduce further evidence directly to show that the issue was wrongly determined. Only remedy is to offer the higher court if available. Explanation of the issue between the parties is rights who has voted about an issue estoppel. It operates in any subsequent proceedings the issue has been determined. It also operates in the subsequent suits with the same parties in which the same issue has arisen. So then of the level of the court of civil procedure contains also the reciprocata, but which are not exhaustive of the general doctrine of reciprocata. Legal principles of estoppel and reciprocata are equally applicable in proceedings that administrative authorities, as they are based on the policy. Now, if we have approached the constitutional court, the constitutional court once has already made a review that its life cannot be considered after a delay of 20 years in Amurma. Secondly, the authorities do not have any jurisdiction to deal with the matter of the fact. You can't go back to the authorities and keep on knocking at their doors and then come back to your license and say that his license of 1997 is fraudulently transferred, therefore he wants a further inquiry into the matter. He keeps on repeating that there is a CCTV report. The division bench has already taken a view that it was without jurisdiction. The learned secretary ought not to have done it.
Yes.
Now, of the foundation, it's like the basis on which this qualification arises. Everything, whatever is asking is very verifiable, or it is coincidental. Now, this is a coincidental which is filing. The main transfer itself is not interfered. Now he says that the renewal should be interfered with by the Honorable Court. But it's too far-fetched. It's an argument which is being canvassed. Therefore, not my respected commission, this matter will not require much.
And two judgments cited by the Honorable Six. These regard to the principles of precedent or stop. Here, my lords, can kindly see. I am not requesting the Honorable Court to decide an issue between the parties. It is already. My respectful submission is there. But from the observation of the Honorable Division Bench, on the next day it was open for me to be before the Honorable Supreme Court, with regard to the observation made in the course of the order.
You have not approached the apex court.
Could not, because my doors are closed, my liberty given.
But he is given to approach the competent court of law.
Competent court of law, I mean, there is no competent court of civil law, because there is a bar.
But your petition is not maintainable before the excise commissioner. In light of the judgment of the division bench.
The Honorable Division Bench did not say that it is not maintainable because
First part, if you read, it says that the excise
we have
commissioner.
to read the directions. Observations in the court, then it is open from the other side to take up that plea. Before the excise commissioner, if you hold an inquiry.
Direction.
Yes.
Come to the para number 29.
29, I may be permitted to
Having
just come. It is clarified that the authorities under the 1965 and the rules based around would be entitled to 1965 Act is Karnataka Excise Act. Thereunder would be entitled to initiate any inquiry with regard to the violation of the provisions contained thereof in respect of the transfer of license. The Excise Commission is an authority under the Excise Act 1965.
This order
This order would also not foreclose the legal remedy or option, if any, available to the petitioners before the competent court of law, forum, or authority, and the petitioners are referred such remedy as may be permissible under law. No Maratha kindly permit me to read section 68 of the Karnataka. This has been decided by the Honorable Division Bench in the case of Bangalore. 68. Yes. B. This happened, why this happened was that the Lord, the legislator in amended section 68.
When you take a plea of fraud,
yes.
So that is how this observation was made.
Yes, yes. I don't think the Honorable Division Bench. Gone to the Honorable Supreme Court, they have written my application that there be a many cap, they are a liberty job. That is the reason after examining, otherwise 68B will be permitted. I may be permitted to plan history of section 68B also. Those were the days I also heard in the morning on arrest contract. The arrest contractors used to defraud the state of the payment, go to civil court and take on injunction. Issue section 18 notice. To prevent that, the legislature blocked the way of civil court for jurisdiction of the civil court. No civil court shall have jurisdiction in respect of any matter which any excise officer, other authority, empowered by or under the Act has to determine, and no injunction shall be granted by the court in respect of any action taken.
You are not to go against an order of an excise officer. What you plea is that by fraud they have obtained this license.
That is to be determined whether the license could be renewed or not. The renewal is done by not other person.
Transfer is already attained finality. Now this question was only of renewal. Is it?
After the death of my husband, children are very small.
Correct, we understand that.
They have created a fictitious person,
But then you are stating that there is a fraud played upon you. That fraud cannot be adjudicated by an excise commissioner. That has to be done before. That has to be done by an appropriate forum.
Fraud means not from an offence under the then Indian Penal Code, the action of transfer of license or renewal of license, transfer is rule 17B. 17B is to be done by excise officer only. That is, in the normal court, there will have an appeal. Having gone before the Honorable High Court and all, the division bench has given me the complete liberty. I do not know why the other side feels shy to go before the excise commissioner, take part in the proceeding, let him argue all these aspects of the matter.
Yes.
That's how I understood the submission. And so far as the decision cited, definitely, that's why I was same decision right from court of government to court of another party. Until I take this case, not getting used. That is not applicable to this case. Stop. And finally, I will take your answer to the first page of the judgment. Before the Honorable Division Bench and the single judge, there were two appeals. This is Honorable Division Bench, there are two appeals. Page number 106. Timothy Savita K.R. Page number 106, copy of the judgment. Timothy Savita K.R. So and so. First, appellant in writ appeal number 1318, represented by Shri D.R. Ravishankar, Senior Advocate, Ravindra Prasad, so and so. Now come to the next appearance. K. Manjunath, the present party here. So and so, writ appeal 26 of 2023. K. Manjunath, represented by.
You're contending that the
No, there is a conflict of interest because I was suddenly of yeah, I have done close to 50 years Indian here with a strong fairness. Fairness before the court and telling truth before the court. Not telling why you are doing this and that. This is only my lord's observation I am only bringing of the honorable court. And there are two persons. First answer is Savita. Here she is not a party, no doubt. Because I have no cause of action against Savita because she has already given the responsibility.
There is no conflict of interest between.
My submission
Is there any? Is there any?
Much is spoken about my delay. Much is spoken
Let us
about
not
my-
say anything.
No, I am sorry. I only take the point not to delay. Much is spoken about my delay. Both these interprets are time bound under the limitation. There is not a single line by the honorable Division Bench delay condoned or delay application is considered. There is no deemed consideration condonation of delay. It is because the honorable Division Bench. I am entitled to tell the truth before all the courts, all the judges, whether it is a division bench or the honorable single judge. See, now I get maybe few days delay, then it is condoned when sentence it is added. I have no answer at all. My delay is answered in para like that, stating that I had filed an MVC case. He died in a motor accident. MVC case, my lords are known. If my income is 10 rupees, my lawyers will make it 100 rupees. So that out of 100 rupees claim, at least 25 rupees will come in the evidence and all. So there was a intention that there was an excise duty. She said he was into excise duty. He was innocent lady, uneducated lady, innocent lady with small children and he died. What did the lawyer? She goes to the lawyer and signs the claim petition. That is taken into consideration to protect the government bullying against.
In the motor vehicle accident cases,
Yes.
income is usually shown high, so that they get a better compensation.
That's why.
It is same like the bride and the bridegroom, when he sees a girl, he says his income is very high and he's working in a very reputed company. But when comes to maintenance, he will definitely say that, no, I am not even earning.
I do not know what happens to the lawyer. The guy is a lawyer, what is their opinion?
No, it is no.
So my submission is that, my lord, honestly, my lord, I am placing the information to the court that
You are before a wrong forum, Mr.
it is not. I am before I accept that excise commissioner. There is another forum is there for me.
You have to go there.
No, and I submit, my lord. 61, 62 of the Karnataka.
There are two options available. When you say that a fraud has been committed on you, you have a legal remedy.
No, because that is Yeah, I cannot go. Commissioner can file a complaint. That's not my case. I have thoroughly examined it. But another one is that section 54 is there. Division to the government. The government, but normally what happens is that the hearing is, if it is done by the finance secretary who is additional, this is difficult normal. Many occasions, minister will sit as a presiding officer. That creates it because he is not, he is not a legal expert. That is not, though, not that much sound for me to say that. I am telling you about real aspect of the matter. Here, there is some material place to say that what is done against the court. The deputy commissioner of
Even
excise.
if you direct the excise commissioner to consider your
Yes,
application,
that's all.
that would be one without jurisdiction.
No.
That's all.
My submission is
Your,
that I am
if you go in a wrong direction,
there is
you
no
get,
other court.
until you ask a question, right question, you won't get a right answer, right?
The other side says that what is the other forum? We are saying that we don't have the forum. Let them see. What is the other forum? I cannot go to civil court. Division bench has already applied the court. In the case of Mr. Mango case, Honorable Division bench has applied that section 58B. There are also no civil court. It can entertain.
SCGP, what is the other forum available to them? SCGP. What is the other forum available to them?
In all fairness, we should say.
She can set section.
Correct. That is what, by the excise committee.
Excise authority cannot be action. It's so very obvious because the answer lies in what he is saying, but he does not want to express it. That's it. My letter celebrant has already given the answer. He read section 68, he knew where the answer lies. Doesn't matter.
But of course, the question asked to the government.
Yes, government. What is your answer? Applicant. No, where he has to go?
Where it is not safe.
But suit is in respect of an excise commissioner's order. What does it say? 68.
Everything will be done by the excise authority.
Yes. Similarly, under the Karnataka Act, wherever the law is
Don't stay.
say that whatever issues can be said under that statute by the officers stated under that statute. Cognizance of such kind of dispute and the issues cannot be by the city. But when it comes to the question, because I can understand there is no interpretation by the interpretation by the division bench clearly says binding is also binding on me at the next step because the issue is not. So the issue which binds both the parties. It is already said that this is not an issue which can be decided by the excise authorities. Goes out automatically. What's the line?
Because anybody can answer that. Yes, yes.
Those who are legal proceedings shall lie against the state government or any excise officer or any other proceeding for excise bills or to perform functions under this act or anything that is good faith by intended to be done.
Come to 68B. All civil courts shall have.
From any matter which any excise officer other than the authority employed by or under this act has to determine and no injunction shall be granted by any court any action taken or to be taken by such excise officer or authority in pursuance to any power conferred by him or under this act. So whatever is referable to is as long as an excise authority is exercising powers under the act, then that cannot be subject matter of the jurisdiction which can be exercised by the city. Now the issue which was raised, which are then specifically said is not an issue which can be inquired into by the excise authorities under the act and 68 goes on.
So he can go before the civil court in like.
I mean, this kind of problems are very included civil perspective. You also even in the work point was included. Says that words are very specific. Respect of those matters which are capable of being decided under that act. Not so For everything, the Peninsula is section 9. Section 9 is the Peninsula for everything. Plus the express bar is there. Express bar is not applicable in the Constitution. Side. They can't again go back to the same authority, having found a finding in the decision, it stops saying that excess authorities in Karnataka push it.
Yeah. You should see the kind of machine. Page number 24. The first order of transfer after the death. Page number 24, type to copy is page number 25. P and Papana. This is done exercising the powers under section 17B of the General Condition Rule, not by any other law. So, this 68B applies here. It is not that my electricity power is disconnected to the shop or something like that. My license has to be transferred by applying Rule 70B of the General Condition Rules. That means it is done by the excise officer. If it is within the period of 90 days, I would have an option of alternate remedy of appeal to the excise commissioner. I did not. Years went on. Thereafter, I came before the Honorable Court. My Honorable Judge allowed the petition, however, in the division bench, but complete protection is given to me by the Honorable Division Bench. But for the protection, my lords, the matter would have to take a different course. I would have to definitely advise the party to SLP. That is not there. SLP will not stand for a
You
need.
should have gone for a clarification before the learned, before the division.
Because you also,
No, not a, your clarification of the order of the division.
question to the Honorable Division Bench.
No, see, it is a right available to a party. You have to seek for clarification.
I fully obey.
Not the question of obeying, it is the question of, it's a question of understanding the actual liberty.
The excise commissioner sets as jurisdiction. Why did he keep it tied up in the rocket and kept? He could have sent it back to me that I am unable to do anything for you. The application is not
If
ready.
the government was functioning so very promptly, then this one all would not have arrived.
Because in one day. My submission is that let the government, the government is not saying no for this.
He's not saying no.
He is not saying.
What do you say, Mr. Wood?
The information was that if there is a direction, there is
Excise Commissioner has not jurisdiction.
a direction.
Then why were no orders were passed by?
Yes. Yeah, but
They have to go to the right forum.
Justice is still having done. Both of us can take half an hour and
Tomorrow for dictation. Yes, Mr. Prabhakar.
For the respondent one.
Election B, page 102. Is the order impugned in district petition?
Be little louder, Mr. Subramanya. Be little louder.
Yes. My lord, annexure B, I think my lord can able to hear me.
No, not
Annexure,
very.
annexure B, annexure B, page 102. Is the order impugned in district petition, wherein the first respondent has accorded permission to the union, trade union, to prosecute the managing director and also the divisional manager on the allegation that I have not implemented the award dated 27/2001 passed by the industrial tribunal, which is at annexure A.
What is the award?
Award is, my lord, your lordship may kindly come to page 19.
Relevant portion, page 35.
Yes. Operative portion is at page 35. the first party employees are entitled for the pay scale as per the fourth commission scales or NTC pay scales on par with the employees of the divisional office of the second party. The second party is not just, we are concerned only with this, my lord. We are concerned
So he
only
has
with
to
this.
be given pay scales as per the fourth commission.
My lord, I will come to that. My lord. I will narrate the brief facts also. My lord, on the face of it, my endeavor is to convince your lordship that the order passed is totally without application of mine, and the authority has also passed the order hurriedly to comply with the direction given by the Honorable High Court. Now, in this connection, my lord, on the face of it, I will narrate the facts in detail. Kindly come to
Mr. Subramanian,
annexure.
the
Yes, ma'am.
sanction is non-compliance of this award. This award has attained finality. This award has
That award
attained.
has a finality.
So you have to pay the employees as per the pay scales, right?
According to me, I have paid.
According to you,
I will refer the documents, my lord. About 150 documents are there. I will refer. Now, before that, my lord, I wanted to show how the order is very bold and without application. Kindly come to page 102.
102.
I'm 101.
Yes,
101. My lord, on 31/5/2022, the proceedings were
page
held.
number 101, right? 101.
Annexure U, page 101.
Yes, yes. Both the parties are present.
Yes, I will just read these proceedings, my lord. Both the parties were present when the conciliation officer and the deputy chief labor commissioner central Bangalore inquired about whether there was any possibility to coming to an understanding as directed in the first meeting. The management submits that they have made all efforts but in vain. The union has not come to an understanding to settle the matter. Further, the management submitted that the statement along with the documents, the same has been taken on record and a copy of the same has been given to the other party. The management submit that the award has been implemented fully and hence no need to accord sanction to file prosecution against the management.
Yes.
In the meanwhile, the management has brought checks drawn in favor of the employees towards settlement of this award, whereas the employees union have refused to accept the checks. Whereas the union stated that the management is not at all implemented the award fully. According to them, it is not implemented award fully and implemented the award partially. That is their case.
Yes.
And handed over checks to few people by force and hence requested to consider their representation and grant sanction to file prosecution against the management of NTC. Versions of both.
These checks were given to them during the pendency.
Given to them that they have returned the checks. Next, versions of both the parties heard and their submissions taken on record. Proceedings are concluded and reserved for orders, keeping in mind the direction given by the Honorable High Court, Bangalore, in writ petition number so and so. According to the direction given by this Honorable Court, the authority was to pass order on 31/5/2022. Now, the order was reserved. The proceedings, my lord, proceedings went on up to 6:30 evening on that day, 31/5/2022. On the same day, the order discloses as if the order was passed on the same day, 31/5/2022. Your Lordship may kindly permit.
Yes, yes.
Reserved for orders. On the same day, the order discloses as if the order was passed on 31/5/2022. Now, page 1 ink page 102 to 104. It is only discussion of both the sides.
What is
Only
the direction issued in that writ petition?
Miller?
What is the direction?
My lord, there were proceedings were pending before the first respondent right from 2017. He did, the first respondent did not make progress. The trade union has filed writ petition seeking in the year 2018, seeking direction to the first respondent to complete the proceedings and accord permission to prosecute the management. This honorable court gave direction. Your lordship would get it at gave direction to pass order within 4 weeks. Your lordship would get it at annexure. Annexure R, page 88.
Yes.
Page 88. Operative portion, my lord, is at kindly come to para 7, my lord. Having regard to the fact that for more than 7 years, the Supreme Court order said to have not been complied, the petitioners are permitted to make a representation to the appropriate authority seeking sanction to prosecute the respondent numbers 3 and 4 within 2 weeks from the date of receipt of the copy of this order. The appropriate authority, respondent number 1 and 2 shall consider the said representation within 4 weeks from the date of receipt of the said representation. On 4/5/2022, they have given the representation. The authority was required to pass order on 31/5/2022.
That is how this order
Now,
can be in a hurried manner, according to you.
it is in a hurried manner, but with disturbed mood. That is my submission. I will make out. Now, your lordship may kindly see. Kindly come to 104.
The order of the before this court. What was challenged before this court? To initiate prosecution.
Well, challenge what? The proceedings were pending before the first respondent. They had sought permission to prosecute the management way back in the year 2017. Several proceedings were held, but the authority kept quiet. Authority did not proceed from 2017. Therefore, they filed writ petition in the year 2018. In the year 2022, writ petition was disposed of, giving a direction to the authority to consider the representation and pass orders within 4 weeks.
Yes.
Within 4 weeks. Authority commenced proceedings after 26 days. Because within 28 days, order should have been passed. Authority commenced proceedings on
26/5/2022.
So it was to be completed. Order was to be, authority should have sought for extension of time also. It was to be concluded on 31/5/2022. He reserved the orders at 6:30 evening on 31/5/2022. It is surprisingly, the order discloses as if all the contents, as if the order was passed on 31/5/2022.
Yes.
Now, my lord, kindly see my compliance report.
Where is your report?
Okay, I will take your lordship to compliance report. Compliance report is at annexure K, page 73. Entire. No, I am sorry. One second. Compliance report is at annexure T, page 96. It was filed on 31/5/2022 before the authority. This is compliance report.
Filed on the very day itself, 31/5/2022.
On 31/5/2022. The case was heard on 31/5/2022. My lord, compliance report is running from page 96 to 100. along with all
This report-
annexes.
This compliance report was not even considered.
It is not even adverted to. I will take your lordship to that. Now, I request your lordship to kindly take up my spiral binding manner. This is the compliance report. I have not enclosed, I have not attached all the enclosures.
Yes, sir.
Kindly take up the compliance report. This is the compliance report. I have not attached all the documents. It is not the. No. It is not that. That is judgments, I believe. Compliance report.
Yes.
Running from pages 141 pages.
Yes.
Yes. My lord, kindly come to your lordship may kindly come to page 6, 7, and 8.
Yes.
Page 6, 7, and 8. When the matter reached finality, only 3 people were working. 3 showroom employees were working. I have produced that their pay scale has been revised on par with the award. Next, I have produced calculation. Calculation runs from page 9 to page 98. Calculation of all the showroom employees who are covered under the dispute. Page 9 to 98. Then, your lordship may kindly come to page 99. I have contended during the pendency of the conciliation, I have paid 50% of the award amount to the 12 workmen. Your lordship may kindly see page 99. Amount has been received. Amount has been, there is no protest. Like that, page 100. Amount has been received. Page 101. Amount has been received. 102, 103.
How many
104,
workers involved
105.
here? How many employees are involved here?
Totally 24.
24.
Totally 24. Because 2 people, they took a voluntary retirement even before passing the award. 26 were covered. 2 people took voluntary retirement before the date of award. Therefore, my respective submission to your lordship is 24 are covered. I have paid 50 during the pendency of the conciliation. I have paid 50% of the total amount to the 12 workmen whose receipts acknowledgement is here. They have not disputed. And I have paid 100% to the remaining 2 legal heirs of 2 deceased employees. 100% I have paid. For the remaining,
yes.
For the remaining, I have issued checks. Your lordship may kindly turn to page 128. To 141.
Yes, now the sanctioning authority or the authority which has granted prosecution has not considered these documents.
These documents were very much before the authority. Authority in proceedings also proceedings refers, but in the order totally silent. Now, these documents were not at all considered by the authority. Your lordship may now kindly come to page 103.
Yes.
Page 103.
No. Yes.
Page 103, last paragraph. During the course of meeting held on 26/5/2022, in the office, the complainant union once again alleged that the management has failed to implement the award and sought permission to prosecute the management. The representative of the management submitted that there was confusion as to the number of persons eligible for receiving the benefits, and hence the award could not be implemented in full. He prayed for some time to look into the matter and submit their reply. The discussion was adjourned to 31/5/2022 with a direction to the management to discuss the matter with the union and to draw a concrete proposal for implementation of the award. However, during the course of discussion held on 31/5/2022, the management failed to produce the material showing the action taken for implementation of the award, and the association representation reiterated the demand according permission for prosecuting the matter. The management have brought checks to hand it over to the applicant union, but they have refused to accept the same.
Yes.
It's a totally non-application of point. 141 documents were placed and copy was given to the trade union. And this is a serious matter involving granting permission to the trade union to prosecute me. Authority has not taken even minimum pain to read the compliance report.
Yes.
The authority, the matters of this nature.
Yes.
Admittedly, I have given calculation. Admittedly, I have given checks for the remaining amount.
Yes.
Remaining amount. They have not furnished any calculation before the authority. They have not said how it is not implemented. And their case is that it is partly implemented and not fully implemented. Fully implemented. Not even a single document is referred.
Yes.
And the date of passing the award itself is doubtful. Proceedings were held up to 6:30 and the order was reserved. On the said day, I don't know how this order could be passed without even considering.
Yes.
It's a single document. I'm not going into the merits now. And it is not a case of authority only records. Checks were given, but they have refused to accept it.
Yes.
They could have taken the checks under protest and they could have given the calculation. No calculation is given before the authority. And they did not even say that how my calculation is bad. Therefore, the authority has hurriedly passed the order granting permission to prosecute them.
Yes.
Now, my lord, I will rely upon few judgments in support of my case. This is a spiral binding book which I have given.
Yes.
First judgment, that is the case of SN, ADA and others versus Bini Limited. I take your lordship to para 13.
Yes. Yes.
Para 13. As we look at the matter, interpretation of section 34 would be easier if the scheme of the act, especially penalty provisions, are kept in mind, as cognizance of a complaint under section 34 is taken by a magistrate only with regard to the offences specified therein. Under the act, two parties between whom lists exist are the employer and the employee. An offence of which complaint can be made would be committed either by the employer or by the employee. By enacting penal provisions, the aim of the legislature is to ensure compliance of the order of the tribunal and also to ensure obedience and compliance of the provisions of the statute. By non-compliance or disobedience of any provisions of the act, it is an individual right, either of the employer or of the employee, which is affected. The intent of legislature in enacting a provision like section 34 is to save the party against whom the complaint is to be filed from harassment, and it is for the reason that the government is required to apply its mind and determine the propriety of filing a complaint. The phrase "under the authority of the appropriate government" implies a sanction by the government after it has considered the desirability of prosecution. If such a provision had not been enacted, there could be every likelihood of filing of frivolous complaints indiscriminately. Moreover, there are certain offenses which have importance either to the employer or the employee only. In such matters, why should government at all involve its officers in filing the complaint and not allow the real aggrieved party to prosecute the complaint properly and diligently? What interest can the government or its agency have in filing and prosecuting a complaint in which the rights of some... My lord, here I am only relying upon the judgment that there is no application of point. There should be application of point. Next, my lord.
Which is the next judgment you are relying?
I may not rely on all the judgments.
Which is the other judgment you are relying? The first judgment and
First judgment and next yes, my lord. Kindly come to page 44. That is a that is sixth judgment.
Yes.
Sixth judgment. Para 11 and 12. Para 11 in page 49. Where is my lord?
Yes, yes.
Para in page 49, para 11.
Yes.
Reasons introduce clarity in an order on plainest consideration of justice. The High Court ought to have set forth its reasons, howsoever brief, in its order indicative of an application of its mind, all the more when its order is amenable to further avenue of challenge. The absence of reasons has rendered the High Court judgment not sustainable. Even in respect of administrative orders, Lord Dennis also observed, the giving of reasons is one of the fundamentals of good administration. In
Yes.
Alexander Machinery, Durga Limited versus Cabot Tree was observed. Failure to give reason amounts to denial of justice. Reasons are live links between the mind and the decision taker to the controversy in question, and the decision or conclusion arrived at the reasons substitute subjectivity by objectivity. The emphasis on recording reasons is that if the decisions reveals the inscrutable face of the things, it can by its silence rendered it virtually impossible for the courts to perform their appellate function or exercise the power of judicial review in adjudging the validity of the decision. Right to reason is an indispensable part of a sound judicial system. Reasons at least sufficient to indicate an application of mind to the matter before court. Another rationale is that the affected party can know why decision has gone against him. One of the salutary requirements of natural justice is spelling out reasons for the order made. In other words, speaking out. The inscrutable face of speaking is ordinarily incongruous with a judicial or quasi-judicial performance. Then, my lord,
Yes. These two judgments are enough, Mr. Brahman. Speaking order illa, and one is reasonable order.
ಸ್ಪೀಕಿಂಗ್ ಆರ್ಡರ್ ಇಲ್ಲ ಒಂದು ಡಾಕ್ಯುಮೆಂಟ್ ಕನ್ಸಿಡರ್ ಮಾಡಿಲ್ಲ ಅವರು. ಇದು ಮಾಡೋದಕ್ಕೆ 8 ವರ್ಷ ಇಟ್ಕೊಂಡಿದ್ರು ಫೈಲ್ ಪೆಂಡಿಂಗ್ ಅಲ್ಲಿ. ಅವ್ರು ಹೇಳಿದ್ರು ಇವರು ಇದು ಹೇಳಿದ್ರು, ಇಲ್ಲಿ ಅವ್ರು ಮಾಡಿಲ್ಲ, ಇಷ್ಟೇ ಆರ್ಡರ್. And hurriedly, it has been passed hurriedly. Next, my lord.
ಅಲ್ಲ ಸಿಮಿಲರ್ ಇದು ಇಶ್ಯೂ ಇದ್ರೆ ಬೇಡ.
ಇಲ್ಲ ಸಿಮಿಲರ್ ಅಲ್ಲ, ಸಿಮಿಲರ್ ಅಲ್ಲ, ಬೇರೆ 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 ಬೇರೆ. I have filed rejoinder today. ಕೋರ್ಟ್ ಅಲ್ಲಿ ಕೊಡ್ತೀನಿ ರಿಜೈಂಡರ್.
ಆಯ್ತು.
ಅದರಲ್ಲಿ your lordship may come to page 27.
Yes.
I take your lordship to paras 14 to 20.
It is only when it is found that the accused persons have not complied with the court orders, court directions. ಅದೇ ಅಲ್ವಾ, it is only when it is found that
ನಾನ್ ಕಂಪ್ಲೈನ್ಸ್ ಅಂತ ಇದಾಕಿದ್ರು, ಅದು ಕಂಟೆಂಪ್ಟ್ ಅದಕ್ಕಿದ್ದು. It is only when it is found that the accused persons have not complied with the court orders or court directions and have disobeyed or violated deliberately, revealing a contemptuous conduct, then to uphold the dignity and majesty of courts and to ensure that the efficacy of rule of law, the contempt jurisdiction is exercised. Unfortunately,
how is it relevant, Mr. Subramanya?
Relevant page 19.
Mr. Subramanya, how is this relevant?
Because we have, once we have paid the amount.
The petitioners are the contemptors. This
contemptness for there also they have filed the contempt, alleging the non-compliance of the order.
The respondent
amount has not been paid. Therefore, this honorable court held that in such cases contempt would not arise. We are not here to calculate the amount. If there is any difference in calculation, you have to approach the proper forum.
Yes.
Here also admittedly they have received the amount, and admittedly we have given the checks.
Yes.
Checks. When even assuming part payment is made, their next course of action is to file application under section 33C2 for computation of the amount.
Yes.
That's yes. For this purpose, I am relaying them. Para 15, my lord. Contempt jurisdiction cannot be used as jurisdiction to terrorize any person to succumb or to put
that
any
is in
person.
The context of contempt jurisdiction.
Yes, as contempt jurisdiction. Here also they are giving the permission to prosecute me on the allegation that I have not complied with the award. ಅಲ್ಲ ತಾವು ಇದು
ಅಲ್ಲ ಬೇಕಂತಿಲ್ಲ ಮಿಸ್ಟರ್ ಸುಬ್ರಹ್ಮಣ್ಯ ಅವರೇ, ಇದು ಈ ಜಡ್ಜ್ಮೆಂಟ್ ಬೇಕಂತಿಲ್ಲ. ನಾಟ್ ನೆಸೆಸರಿ.
ಅಲ್ಲ ನನಗೆ ಇದರಲ್ಲಿ ನೋಡಿ ಬೇರೆ 39 ಅಲ್ಲಿ ಇದು ಇಂಕ್ ಪೇಜ್ 39.
ಅದು
is pertaining to
same content.
Page number 39. It is pertaining to NTC only.
ಅದು ಇದು ರಾಂಗ್ ಕ್ಯಾಲ್ಕುಲೇಷನ್, ಪ್ರಾಪರ್ ಕ್ಯಾಲ್ಕುಲೇಷನ್
ಕ್ಯಾಲ್ಕುಲೇಷನ್ ಪ್ರಾಪರ್ ಇಲ್ಲ ಅಂತ ಹೇಳಿದ್ದಕ್ಕೆ ಕೋರ್ಟ್ ಹ್ಯಾಸ್ ಅಬ್ಸರ್ವ್ para 3 in page 43. It is pertaining to NTC only. In fact, before the learned single judge, a sum of rupees 15 lakh came to be was deposited by the management on 8/8/2007.
Yes.
The balance amount as per memo dated 16/2/2017 is said to have been paid by the management employer to the workman. However, C. A.M. Patil, Learned Counsel, appearing for the complainant, would contend that there is a miscalculation, wrong calculation, or improper calculation, and as such, he
Contempt
seeks
is very in a narrow compass. There is an order,
narrow compass.
non-complies. Non-complies. You cannot
Non-compliant.
go
Here
beyond.
also, here also, my lord, they are seeking permission to prosecute me for non-compliance. Their contention is that award was not fully compliant.
Yes.
In that connection, court said, even contempt court said, which is much more serious, contempt. Contempt court said, we are not here for calculation, you have to approach the right forum. You cannot say that they have deliberately failed to comply with the order.
Yes.
Next, my lord. I have filed one more list of citations today.
Yes.
One more list of citations.
ಅದರಲ್ಲಿ ಯಾವ್ದು
In page-
ರೆಲೆವೆಂಟ್ ಅಷ್ಟೇ ಹೇಳ್ಬಿಡಿ
Huh?
ರೆಲೆವೆಂಟ್ ಜಜ್ಮೆಂಟ್ ಒಂದೇ ಹೇಳಿ.
ಇದರಲ್ಲಿ ಎಲ್ಲ ರೆಲೆವೆಂಟ್ ಇದರಲ್ಲಿ 4 ಜಡ್ಜ್ಮೆಂಟ್ ಇರೋದು ಒಂದೊಂದು ಪ್ಯಾರಾ ಅಷ್ಟೇ ನಾನು
ವಾಟ್ ಇಸ್ ದಿ ಪ್ರೊಪೊಸಿಷನ್ ಆಫ್ ಲಾ ಅಂತ ಹೇಳಿ.
ಎಸ್ ಪ್ಯಾರಾ 10 ಮೈ ಲಾರ್ಡ್.
ಅಲ್ಲ, ವಾಟ್ ಇಸ್ ದ
Para 10.
ಪ್ರೊಪೊಸಿಷನ್ ಆಫ್ ಲಾ ಹೇಳಿ ಮಿಸ್ಟರ್ ಸುಬ್ರಹ್ಮಣ್ಯ. ಇನ್ ವಾಟ್ ಕಾಂಟೆಕ್ಸ್ಟ್ ಯು ವಾಂಟ್ ಟು ಡಿಸೈಡ್ ದಿಸ್?
This is application of mind.
Yes.
Yes, application of mind. Para 10 my lord.
ಓದ್ಬೇಡಿ, ಹೇಳ್ಬಿಡಿ ಅಷ್ಟೇ. ಪ್ಯಾರಾ 10.
Application of mind, and the authority also should analyze for other alternative arrangements.
Yes.
Next. ಇದು
ಅಷ್ಟೇ ತಾನೆ.
ಇದು ಇನ್ನೊಂದು 33C2 ಇಂಕ್ ಪೇಜ್ 9. Ink page 9. This is 33C2. I will read only para 10, my lord. Para 10. Kindly come to page 12. Page 12. Early 8th, item 8. Since proceedings under section 33C2 are analogous to execution proceedings and the labor court called upon to compute in terms of money the benefit claimed by a workman is in such cases in the position of an executing court. The labor court, like the executing court in execution proceedings governed by the CPC, is competent under section 33C2 to interpret the award or settlement where the benefit is claimed under such award or settlement, and it would be open to it to consider the plea of nullity where the award is made without jurisdiction.
Yes. ಆಯ್ತಾ? That's all ಅಲ್ಲ ಮಿಸ್ಟರ್ ಸುಬ್ರಹ್ಮಣ್ಯ ಅವರೇ?
ಇಲ್ಲ, ಇದು ಸ್ವಲ್ಪ ಇದೆ.
ಇನ್ನೊಂದು ಯಾವುದು?
ಅಲ್ಲ, ಇವಾಗ ಏನಿದೆ ಅಂತ ಹೇಳಿದ್ರೆ ಏನಿಲ್ಲ. ಅವರು ನಾವು they have filed objection. They have given calculation saying that each worker is entitled for 1 crore. Total 34 crore claim ಮಾಡಿದ್ದಾರೆ. ಹೆಚ್ಚು ಕಮ್ಮಿ ಅಷ್ಟು. No calculation was given before the authority.
Yes.
No calculation was given. They have not disputed my calculation. They have they have accepted the 50% of our amount without any reservation.
Yes.
Had they given their calculation so that authority would have examined or we should have examined. Therefore, my submissions to your lordship is, they cannot file calculation and other benefits for which they are eligible in writ jurisdiction, my lord. That's all my submissions.
Yes. Yes, Mr. Somshekhar.
Sir.
Yes, senior counsel.
Millards, my first submission is answering the last contention of Mr. Subramaniam that you should go under 33C2 of the ID Act for computation. If that is the case, I'll be very happy because the entire law with regard to prosecution for violation of award becomes redundant. Because we can drive the unions and the workmen to 33C2 for another 10 years. Kindly see in this case, my lord, not much of an argument would be addressed by me, but based on the documents produced by them, to show how unfair this corporation has been, which is a government agency, and for the lowest paid employees, the award is of the year, award is 2001. We are in 2024, and 23 years they have not been paid their dues. Now kindly see, my lords. The two documents your lordship may kindly see. Kindly take my additional statement of objection filed on 15/3/2024.
Yes.
In that, your lordship gets 15/3/2024, annexure to Q anta.
Reply to the rejoinder statement.
In my reply, additional statement of objection I filed in reply to that. If your lordship gets that, my lord, at R2Q ಅಂತಿದೆ. 15/3/24 ಅಲ್ಲಿ ಹಾಕಿರೋದು.
Page number?
Page ಅದು ಇದು ಇರೋದೇ ಎಷ್ಟು? Page 6, internal page 6. R2Q ಅಂತ small paper book ಅದು.
Court office.
It is on 15/3/2024.
15/3/2024, where there is one statement of objections.
Additional statement.
Additional statement of objection.
Yes.
But kindly see in this one, page 6, my lord, R2Q. R2Q.
Yes.
Now, my lord, this is what corporations furnishing of information under RTI. Kindly see the pay scale of the divisional office in the following cadre as of 1986 is not readily available, and the same will be furnished in due course of time. Wonderful people, they don't have of 86 in 2024, they say. Then 2, designation, assistant manager 2000, senior assistant 1640, assistant 1400, junior assistant 1200, attender Khalsi 750. This is the pay scale that they have given. And now, kindly see, the pay scale of the division of marketing employees as well so and so is also given. Marketing employee, that is why we are there. Now kindly see, ಅವರು ಹೇಗೆ ಕ್ಯಾಲ್ಕುಲೇಟ್ ಮಾಡಿದ್ದಾರೆ ಅಂದರೆ, we have paid 50%, they have accepted. We have paid 50%, they have accepted. ಬರೀ ಇದೇ ಆಯ್ತು. They are illiterate people and they have done it. Kindly see the payments that are made. ನನಗೆ ಸ್ಟೇಟ್ಮೆಂಟ್ ಕೊಡಿ, ಅದು 4,100 ಕೊಟ್ಟಿದ್ದಾರೆ ಎಲ್ಲರಿಗೂ.
Where is that?
Now, my lords, they have calculate ಮಾಡ್ಕೊಟ್ರಲ್ಲಪ್ಪ. Annexure. Kindly see my statement of objections, my lords.
Yes.
Along with my statement of objections, I produced R2A page, R2E page 55. Statement of objections, your lordship get, my lord?
Yes.
R25 at page 55.
Yes.
Now, my lord, how they have calculated for that purpose, kindly see, my lord. Page 16 of writ petition, annexure F. This is the same document. Then the names they have given, kindly see, assistant salesman, designation, junior salesman, shop manager, showroom manager, shop manager, senior sales girl, salesman. Now, and then they have given this category. For all these people, see the right side, my lord. Basic pay fixed by NTC as on 27/20. 2021.
Yes.
86 ಅಲ್ಲೇ ಬಂತು 4th pay scale. ಈಗ 20ನೇ ಇಸ್ವಿನಲ್ಲಿ 21ನೇ ಇಸ್ವಿನಲ್ಲಿ ಎಲ್ಲರಿಗೂ ಒಂದೇ ನೆಕ್ಸ್ಟ್ ಪೇಜ್ ಆಲ್ಸೋ ಎಲ್ಲ ಮೆಸಿ ಸೇಲ್ಸ್ಮೆನ್ ಇದು ಎಲ್ಲ 4,100 rupees ಮ್ಯಾನೇಜರ್ ಇಂದ ಪ್ಯೂನ್ವರ್ಗು ಅದೇನೆ. ಆ ಬೇಸಿಸ್ ಮೇಲೆ ಕ್ಯಾಲ್ಕುಲೇಟ್ ಮಾಡ್ಬಿಟ್ಟು ಕೊಟ್ಬಿಟ್ಟು ಚೆಕ್ ನ they cannot expect workmen to get fooled by this payment. ಯಾರೋ ಇಬ್ರು ಹೋಗಿದ್ದಾರೆ, ಅವ್ರು ಹೋಗ್ಬೇಕಿತ್ತು, ಅವ್ರು ಹೋದ್ರು. The NTC must thank itself. But can you cheat workmen to this extent? I am appalled. I appear for private companies, but I don't find even private companies indulging in this. Finally, the 4,100 rupees ಮೇಲೆ ಲೆಕ್ಕಾಚಾರ ಮಾಡ್ಕೊಡ್ತೀವಿ ಅಂತ ಕೊಡ್ತಾರೆ. That is a space scale of a tune.
One question, senior counsel. Now, the sanction authority has passed this order.
What is the single document considered?
Whether this all
new documents ಮಾಡ್ಬೇಕಾ ಇಲ್ಲಿ?
one ನಿಮಿಷ Mr. Subramanya.
I'm sorry.
ಅವ್ರು ಮತ್ತೆ
I am sorry, sir.
Yes, Mila.
Now, this all contentions, is it not available to be urged before the prosecution, before the sanctioning authority, wherein now there is an award passed, whether it is in compliance with the award or not has to be determined by the sanctioning authority while according permission for prosecution. Is it not?
No, kindly see, my lord. I'll come to that also. Well, I understand your lordship's question. I had anticipated also, and quite right. I have to answer this question. Kindly see the impugned order, my lord. At page 101. 103.
Yes.
Now, I'll only read at page 104, first paragraph.
Yes.
However, lordship gets that, 104.
Yes.
However, during the course of discussions held on 31/5/2022, the management failed to produce any material showing action taken for implementation of the award, and the association representative reiterated its demand for according permission for prosecution of the management. Now,
There is the consideration by the sanctioning authority about the documents which have been produced by the management and the workmen. Yes, union.
The authority says the management wanted to produce material, but they have not produced material. How can the authority look to material when it is not produced? He says material is not produced to show that you have complied with it. Not for a moment, my lord, my submission is this one. Assuming for a moment that the order is not all that good. But what your lordship will consider is 23 ವರ್ಷ ಆದ್ರೂ ಇವ್ರನ್ನ ಇಲ್ಲಿಂದ ಅಲ್ಲಿಗೆ they are making them dance without making payment and want to pay on 4,100 rupees and say they have taken ಜವಾನ್ ಸಂಬಳ ಕೊಟ್ಬಿಟ್ಟು ಅದೇ ನಿಮಗೆ ಬರ್ಬೇಕಾಗಿದ್ದು ಪೇ ಸ್ಕೇಲು ಅಂತ ಹೇಳ್ಬಿಟ್ಟು ಎಲ್ಲರನ್ನು ಕಳಿಸ್ತಾರಲ್ಲ, ಬೇರೆಯವ್ರು ಚೆಕ್ ತಗೊಳ್ಳಿಲ್ಲ. ಹೌ ಫೇರ್ ದೇ ಆರ್. In fact, Supreme Court has said time and again, what the lower authority can do, the High Court could do it under Article 226.
Yes.
What the Labour Court does, High Court can redo it under Article 226. No need to remand at every stage.
Yes.
Now, my submission and appeal to your lordship is this. This may not be a 100% case where sufficient reasoning is given, but it is also not a case for remand for the simple reason. Things are not going to change even if it is remanded. Documents are before the court. I am representing before the court that they have paid on 4,000 rupees, which is a tender. I have complied with the award. They have taken without objection, you must satisfy. You are the management. I have done it. Many a times I have been told by the court, don't talk of workmen. You satisfy, you have complied with the award. Let them say, we have complied with the award. I have now pointed out two things. One is the pay scales even according to them at the relevant time. Number two is the calculation they have made as of 4,100, a pune's payment. Let them say how they are justified. And if this court's conscience accept it, court may take any decision.
Yes.
Beyond this, I don't want to make any more submissions.
Yes.
Lord,
Now this annexure
Just-
R25.
Just 5 minutes by way of reply.
Uh,
With due
So,
respect to
Mr.
learned
Prabhakar,
senior
you,
consultant.
Mr. Subramania, you have
Yes,
to
ma'am.
justify that how did you calculate the salary or the basic pay of this workman as 4,100?
My lord, my lord,
Your
there
page
are three
69 of your,
categories. No, I have already justified in my rejoinder. Kindly take up my rejoinder. I have filed it. I have filed rejoinder for that. Your lordship may kindly come to, I will not read all the paragraphs. Today I have filed before this honorable court.
yes,
I have filed rejoinder.
yes.
Your lordship may kindly come to para 2. At the outset, your lordship got it?
Yes.
At the outset, it is submitted that the contents of the additional statement of objection is nothing but expanding the scope of the award passed by the Industrial Tribunal Bangalore in ID number 31/1995. It is an admitted fact that all the 26 were working in showroom till the date of filing new charter of demerits dated 28/1994 by the second respondent. All the 26 showroom employees who are covered in the requisition were represented by the federation.
Yes.
Federation has entered into settlement with the management governing service conditions of showroom employees employed in the marketing divisions in all the states. All the 26 showroom employees were also covered under the settlement dated 14/9/1990, signed between erstwhile management of NTC Limited Bangalore and NTC Division Employees Federation Bangalore. The settlement was for a period of 3 years and valid up to 1/9/1993. In the settlement, the following class 4 employees, they are all class 4 employees. Following four employees are covered. Shop manager. Shop manager means he is not an officer. He is included in the minimum wage notification. It is in the settlement. It is in the industrial settlement. The other side, therefore, the trade union cannot presume that they are the officers. And senior salesman girl, ASM, ASG, junior salesman. A copy of the settlement is produced. I have produced settlement also.
By way of rejoinder, what do you want to contend, Mr.
No, I wanted to contend the designation, the pay scale, because the award is of twofold. Your lordship may kindly turn to.
No, we are not going
Connection.
to redetermine what is the award. Award is passed now. They say
No,
pay as per the court commission.
whether I have complied with the award or not. Your lordship may kindly come to award portion. Award portion.
Yes.
Page 35. The first party employees are entitled for the pay scale as per the fourth pay commission, or option has been given to me. NTC pay scales on par with the employees of the divisional office of the second party. Option has been given to me. I have calculated their pay scale as per NTC pay scale, not a fourth pay or fifth pay commission. That option is given to me. I have calculated. According to that, I have fixed the pay way back in the year. I have fixed the pay. Your lordship may kindly come to page 70. Page 70. I have fixed the pay in respect of 3 workers who are on the rolls as on the date of Supreme Court order. This is NTC pay scale. This was fixed in the year 2016. Nobody objected. Only first now, after nearly 8 years, they are objecting.
Yes.
This is NTC pay scale. Option has been given to me. Now, they say pay has to be revised from 1186. Where does the award say? Nothing is there in the award. We cannot presume, the trade union cannot presume it is from 1186. No date is given. When no date is given, it is implied that the benefits have to be extended from the date of award. From the date of award. Even as, but they are claiming the benefits from 1186, which is not flown from the award.
Yes.
Which is not flown from the award. It must say when no date is fixed, no retrospective effect is given. Therefore, they cannot presume that it is from 1186 and they are eligible for fourth pay commission from 1186. That is not the purport of the award. They cannot seek benefits which is not available under the award. Then they change the designation. They change. Learner Senior Counsel submitted that no, they have not produced the documents. Now, I request your lordship to peruse my spiral binding. It is received, they have acknowledged also. Your lordship may kindly peruse in page 1. Trade union has received and they have acknowledged also.
The trade union,
complaint,
not the trade union, before the authority, appropriate government.
Before the authority only, it is submitted.
It was submitted. Received
It was submitted on 31/5/2022. And nowhere they have disputed my document here. Compliance report is marked. Nowhere they have disputed. And the authority also says.
What's pertaining to the government, appropriate government who sanctioned the order, sanctioned the prosecution, the records would be available there, right?
Yes, they are available. Your lordship may kindly see.
We will see whether the records have been filed there.
Yes. Your lordship may call for the records.
Yes. Call for the records from the Deputy Chief Labour Commissioner.
And they have not filed objection also so far.
Forthwith. This is the matter on Friday. For further hearing. Heard CH-27, learned counsel for the petitioner, Adhakondo, and learned senior counsel, SN Murthy for the respondent. In the list this matter on
Friday ಬೇಡ ಸ್ವಲ್ಪ ಸೋಮವಾರಕ್ಕೆ ಹಾಕೊಂತೀರಾ
Deputy Chief Labour Commissioner Central. Deputy Chief
ಸೋಮವಾರ ಅನ್ನೋದು ಮಂಗಳವಾರ ಯಾವಾಗ ಸರ್
ಮರ್ತೋಗ್ತೀವಿ ಇವ್ರೆ Deputy Chief Labour Commissioner Central. Monday for further.
And even government has not said that these documents have not been placed on record.
Let's see. Yes. On Monday 2:30. 2:30 further here.
Yes.
Number 25, Shri M. Subramanya Bhatt.
Monetary benefits, no?
Yes.
Thank you. What happened pursuant to that, right? What you did with that amount? To keep that amount in safe custody. ಎಲ್ಲೆಲ್ಲಿ ಹೋಗ್ಬೇಕು ಅಂತ ನೋಡ್ಕೊಳ್ಳಿಕ್ಕೆ. Where is that order? Which is that order? 12-2. Is filed for direction directing the respondents to settle the claims of the workmen and grant them the benefits as recommended by the managing director of the company. Then the counsel for the petitioner submit that the petitioner during the pendency of the petition respondent number 2 floated via scheme. And 1,046 employees of the petitioner have opted. So they have opted. It is a submission of that an amount to an extent of 7 crore has been earmarked for settling the claims of the workmen, which is towards the frozen BMS allowance. So this is the details. Then council would submit that the amount at serial number 7 in schedule is not paid in spite of the government of Karnataka and insurance has sanctioned 47. 47, huh? Crores. So. I released a sum of 20 crores under the head of account transfer. It would contain, it is mentioned that the further amount has been sanctioned and would be released shortly. And would contain that no further action pursuant to annexure R, basic transfer has taken place. After that. Then what happened to the 12 crores? No. We have released that amount to them. No. See, now we are not concerned about how much you are going to receive or what you have received. You have received some amount of 47 crores. You have released already sum of rupees 20 crores to the respondent number.
40 crores have been paid.
40 crores have been
paid. Now the question is, what happens to this remaining 7 crores?
7 crores. Now, how much you are entitled to now? DA arrears and frozen.
Managing director, it will be entitled to release of frozen DA and arrears. So for that note, 7.55 crores was earmarked and the demand was sent to the government. Government released the entire amount, including that 7.55 crores. However, what the managing director says is, they have received only 40 crores pursuant to the government order. And the affidavit is also silent as to whether the 7 crores are actually or not.
Is the affidavit there filed now? They say they have received a sum of rupees 40 crores during the year 2002-2003.
Yes.
And respondent number 2 has spent 39 crores towards implementing VRS.
Yes.
Further 2003, so and so. It was extended by the respondent number 1, to which the respondent number 2 has spent a sum of rupees 11 crore to 28 crores, 11.28 crores towards.
So this 12.60 crores has nothing to do as far as 40 crores is concerned. But this amount was sanctioned, released by the government as a loan. So that.
The 12 crores.
Yes, 12 crores. Because the government itself has produced an order wherein it is very clear that this amount has been released as loan. Now both the respondents are not stated anything regarding the 7 crores.
7.55, now the 755 now. There is no point here in the.
Yes. So these are also not annexure fee that I have produced along with the application filed on. 16 Annexure fee on page 8.
2003 na.
67 2003.
What is the order under challenge now before this court?
Now, only direction is what against the government to release the amount towards areas of pay revision and not frozen DA. Our as far as areas of salary is concerned, there is
Now, see, what is the order now in the, just a direction to the respondent?
yes, it's a direction.
Directing the government to implement the minutes of the meeting dated so and so.
Yes.
And to revise the wages of the petitioner and grant the benefits of revised wages as recommended by the managing director of the company.
Yes. However, after filing this petition, this government order came to be issued, releasing 47 crores. So when I pointed out.
Whether you are entitled to.
Yes, they are entitled to like crores and DA. For which only note this amount has been released. You will also be kind enough to see annexure few note that is along with the application filed on 7. That in your lot, that in the earlier order note, there is a reference to this document.
In 7,000, this is the spot.
Yes, annexure few. This is the 53,002. Page 2. Item number 7 in that table. At the bottom of page 8, annexure Q.
Yes.
Lord, item number 7. DA arrears, namely frozen DA plus hardship allowance minus increased DA, 759 lakhs. Lord, this is the request made by the managing director. That is the second response. Pursuant to which, Lord, the government order produced in annexure R, next page. Lord, pursuant to which this amount has been released. Please see, Lord, page 11 of annexure R. Government order dated 8/7/2022. The government is pleased to sanction a sum of 47 crores to Mysore Lamp Works Limited under the head of account so and so for disbursement of VRS to all the employees who have opted for VRS as per the existing guidelines of KSBP along with leave salary, statutory dues, salary dues as per existing salary structure and term benefits as per law. Government are pleased to release rupees 20 crore under the head account so and so. The balance amount would also be released shortly.
The balance is how much now?
That is not 27 crores.
27 crores.
Yes, subsequently, note a sum of rupees 20 crores was released. That is borne out from the documents produced by the government now.
So what remains is the 7 crores.
7 crores.
Now in that 20 crores,
Yes.
whether amount was disbursed to you?
The amount has been disbursed to us except this frozen DA and DA areas.
No, how much would be your entitlement then?
But now, if these two items are distributed to these remaining employees, each one of us will get about 48,000. This covers DA areas and frozen DA.
This annexure R.
Yes.
Annexure R or annexure Q.
Yes.
Is the letter from the managing director.
Managing director to the government.
To the government.
Yes.
Stating that please release the financial assistance to the extent of 47 lakhs.
Yes.
And then annexure R is the order.
Releasing 47, sanctioning 47.
47.
But releasing 20 crores.
So now you are entitled for another 7 crores, which would resolve your dispute.
Exactly.
Yes. Yes, madam. See, there's a letter at annexure Q issued by the managing director seeking for sanction of so much of amount towards the VRS. And then there is a communication of proceedings of the government at annexure R. It says that we have sanctioned you 47 crores and we are releasing 20 crores. And pursuant to the part, there's another amount of 20 crores has already been released. Now what remains is 7 crores. So what is the present status as to when will that amount be released to the petitioners or to the respondent? Correct. So what remains is 7. Annexure R. Correct. Page number 7.
Tabular form.
The serial number 7.
Year, earlier, maybe also the year, hardship allowance, this is whether such amount has all been released, or there is an order from.
You don't dispute that you rather don't take a sentence. Yes, no. No, there are no documents to show. See, entire, it's very clear. 20 plus 20 is there already released. So 40 is already released. So the 7 crores is the amount which is now with you. There cannot be anything which is, neither in their affidavit, neither in the affidavit of the not available. Yes.
From what accounts it was disbursed, and whether this amount was all released the
No, there is a sanction of 47. Yes. Now that is how, if you have released the amount in favor of respondent number 2, that would be available for them. It is not 1 rupees, 2 rupees, it's a 10. And are they not accountable for that? And this is of the year 2002 and 7 crore. Rather, they got the benefit rather very late. And now the petition is of the year 2002. No, what is the material you are going to place before the court? You will file an affidavit to that effect as to what is the present situation and whether the amount is already released to the respondent number 2. Now, in light of the affidavit, they say that amount of 7 crores has not been released. I don't know how the department is working there. Huh? This quote on 12/2/2024. Observe that the respondent state, which respondent? Respondent number 1 has sanctioned a sum of rupees 47 crores. This is the document you are alva. Yes, yes. At an, as per annexure R, dated 8th July 2002. 8th July 2002. The government order dated 8th July 2002 reads as under page 11 of the I and mark the underlined portion. Annexure Q, annexure R, annexure R. To get it clear. The respondent number 2 has filed an affidavit 29/6/2024, stating that the respondent number 2 has received a sum of rupees 40 crores during the period of 2002 and 2003. And the respondent has spent a sum of rupees 39.68 crores towards implementing the VRS. The amount of rupees 7 crores out of the 47 crores which was sanctioned by the government, there is no explanation offered by the respondent number 2 whether they have received the amount from the state respondent number 1. The learned AAG appearing for respondent number 1 submits that an affidavit would be filed by the concerned officer stating as to whether the amount of rupees 7 crore has been released in favor of the respondent number 2. 7.5. An affidavit to that effect to be filed by 1st of October. 1st of October. We are sitting still first. First we are there. Mr. Ramchandra, what happened? Yes, Mr. Prashant. There is no. And what is the dispute about? Direct contract or the contractor? So 50% back wages has been awarded. Reinstated. They have been reinstated now. No, you have been paying back wages. 17B. Regularly paid. So you are not been reinstated. You are not working now. So what remains only is the back wages. The reinstatement is not been. Now they have adhered to the 17B wages, right? You are not gainfully employed anywhere. You are working anywhere. How do you live your livelihood? 17B wages. How is your livelihood going on? So now, what was the settlement offer about?
Offer for 6 lakhs, but totally we have offered for 6 lakhs.
How much would be the back wages and how much would be their entitlement?
They are asking for 3 lakhs.
How many workers? Then settle it. 6 and 9, not a much difference, right?
In 6 lakhs over having the inspections from the management.
Right. You come ahead a little, they'll come back little. So come out to a round figure. Now, if this court says something, will you accept that amount? Yes. No, rather see 9 lakh is their contentions for the back wages or the entire settlement of their claim. And your petitioners is seeking 6 lakhs. Settle it. So you're claiming 9 lakhs, right? Then how did you say it is 9 lakhs?
Yes, that's what I told my lord for the reason that the mediation which was going on, based on that only.
Mediation was there.
Was there, but paid.
Correct. The respondent said that they would be happy with 9 lakhs.
What
Then 15 lakhs is quite a difference. When do you want? Tuesday.
Number 28, PM Narayan Bhatt.
Yes, Mr. Bhatt.
But they granted special casual leave. Chapter 5B was applicable. More than 100 was on my lord. But a dispute was raised.
25M, what is that? 25M.
My lord, all points, my lord, are held in my favor. This was rejected on the ground that I did not reduce evidence to establish that I am not gainfully employed.
No, the establishment is closed.
Not closed. It's not closed. My lord, it is still functioning. What they are doing is, my lord, they are purchasing from outside and they are putting their brand and selling. Workers are all, my lord, retrenched. My lord, this is a difference in wages, my lord, for a particular period.
Tomorrow also.
Let's find it tomorrow.
What is this declaration of special leave?
My lord, instead of carrying a day off, permission is required from the property.
So they give a special.
Special casual leave. They paid 50% to avoid payment of full wages. My lord, this is a method invented by the manager.
Not tomorrow, Tuesday. Tuesday.
Number 13, ABB Sidramaya.
Yes, Mr. Sidramaya. By the respondent, Correct. So what did they on ground of delay, na? What was the ground? On the ground of delay, it was dismissed before the district court?
District court was allowed.
Allowed.
Yes, that judgment have filed this. But this is with respect to right of land under the exam of others.
Correct. No, what did the district court do?
District court.
Where is the order?
But before the order, this decision maker of this number order and the factor. Page number 47.
One nimisha. Now the district court demands the matter to whom? The assistant commissioner.
Yeah. Some decision maker of this number court. Page number 47 has recommended the matter.
Writ appeal nalli, na?
Source was raised by this number court. Page number 47. Last time.
So how about
Last sentence. So far as available from our courts, the other district judge can decide the problem process. First one is.
was the holder of the
One of the village office has only appointed. Second is who are the legal representatives of so called the Karnataka Safa. Ejected the regler, even without filing an application. In terms of the provisions of the act, who is this person ejected the regler?
This was the direction given to the district judge.
Like that. Not decided first and third issue. That's a the matter.
For what reason? As to who is the legal representative of deceased Shivapuji and who was the voter? Why did he remand the matter to the assistant commissioner?
He is the custodian of the records and is having a wide document on the to decide the issue is the court. But that is not the ambit of the remand by this number court. Number court has directed the district court, he can confirm the records. The court can explain over under this procedure code and it can decide.
Yes.
The second aspect, my lord, one more aspect. That I have filed a memo on Sweden. That I tell you, that is better. 2015 memo.
Yes.
Hello. Page number 2.
Is the memo?
7/7/2015. That several appellants, all of the respondents have died. We have made a report to the honorable district court that the some of the respondents have interest over the property. So LR's application to bring LRs of the respondents And appellant was not made by the offense.
You have got the memo. Put up Mercy.
So including the LRs of the appellant and LRs of the contesting respondent. Not also remanded. The LRs needs to be included, all the matters, all the LRs needs to be given an opportunity to.
Respondent number 2, Basamma, was the appellant number 1. She died. She died there. And then loss of appellant number 1 was not brought on record. Yes, then respondent number 8A, loss of Channappa, not brought. So the order is against a dead.
ಅದನ್ನೆಲ್ಲ ನಾವು ಅಪೋಲೈಟ್ ಕೋರ್ಟ್ಗೆ ರಿಮೈಂಡ್ ಮಾಡಿದ್ವಿ ಆರ್ಡರ್ ಕೂಡ ರೆಕಾರ್ಡ್ ಆಗಿದೆ ಸಬ್ಸಿಕ್ವೆಂಟ್ಲಿ ಪ್ರೊಸೀಡಿಂಗ್ಸ್ ಹ್ಯಾವ್ ಪ್ರೊಡ್ಯೂಸ್ಡ್.
Yes, Mr. Counsel. The memo is there. Correct, there's already a memo filed in the MA. It's a court document. Court document. See, you have filed that.
Yes, madam. But they are the appellants before the district court.
You are the appellant.
When they died.
Correct. First thing is, how could the district judge remand the matter to the assistant commissioner when the order of this court was to specifically pass an order in giving free conditions? Then why did he remand it to the assistant commissioner?
He said that
No, that he could have done by himself, right?
it could have been done by himself, but he is not aggrieved by that. He says that the finding that the Shukuji Sandakari Basappa is held to be the whole of the village office, he is aggrieved by that. There is a finding not recorded as per the direction of this court.
See, this court kindly come to the order. The 3 directions were. Correct. Who was the older of the village as on the appointed date? He has to consider that. Who are the legal heirs of Shivapuji Sannakari Basappa entitled to re-grant even without filing an application?
Yes.
And in terms of the provisions of the act, who is the person entitled? He could have.
One and three is concerned, it is as of Milord. One and three is concerned.
Correct.
Only with regard to 2 Milord, at a request consideration, that's why.
He could have called for a finding from the assistant commissioner as to who are the legal heirs. If at all
But
this.
that is an admitted, they are the legal heirs. They themselves admit.
Then why was it remanded? Why was it remanded to the assistant commissioner?
But he is not aggrieved, Milord. He is not aggrieved.
No, that is not the question. Question was the court had specifically directed 3 conditions.
1 and 2, 1 and 3 are.
And then partly, it has to be complied in part, the court's order. It has to be complied in full, right? He cannot redelegate it to somebody else now again. When the court said, you have to look.
To that extent, I agree, Milord. But still, whether he has got any grievance as against that finding, no, Milord.
No.
He says.
See, what happens is, the order of the assistant commissioner is set aside now. The matter is remitted back for fresh consideration.
Only with regard to re-grant, Milord. Who are the legal heirs of?
Does it say so? Does
Yes,
the,
Milord.
where it says?
According that, the bench is Milord.
Appeal is allowed.
Para 8 amount, Milord. Para 8 amount. The Lordship may kindly see. Under the Innovation Act, the point the date on which the act came into force.
No, you just read the operative portion of the order.
The operative portion is, after putting that act is, that my ancestor, Shukuji Sandakari Basappa was the owner of the office. Was the owner of the office, that is answer, point 1 and 3 Milord is answered in my favor. Holding that my predecessor in time, Shukuji Sandakari Basappa was the owner of the village office. Only with regard to Milord, as to who is the elder of Sandakari, the matter was demanded. But now his grievance is that he is the owner of the village office, not the Shukuji Sandakari Basappa.
No, he doesn't claim under Shivapuji.
Yes, he doesn't. I think he is the Lord. Sandakari Basappa is the owner of the village office.
Here the exhaust of not the issue is under the part. And for occupancy rate of payment to amount. Now, my lord, he says, see, very much supply is the vote of the village office. Here, that is negative by the district judge. I can understand, my lord, if he was at the legal there, I put up the village office, and that was remanded.
What was the contention of the petitioner here?
There is he Karibasappa of the order of the office. Petitioner, the daughter of the Karibasappa.
First?
Petitioner is the daughter of the Karibasappa. Actually, is the Karibasappa. The Karibasappa is the order of the office.
But now the first appellate court has held, I mean the district court has held that the holder is Shivapuji son of.
That is not correct.
It is not correct, Anna. Now whether you are challenging the.
Both aspects are correct. Whether one is technically remaining itself is not sustainable. For the reason that it is contrary to the given by the usage of this number code, there are three conditions here are contained number 48.
So far as that aspect is.
In terms of the process of the who is the person intended for regard, plus also to be answered by the district court. Third point I can be point here. Two aspects here, madam. One is that is in terms of provision of that, who is the person intended for grant of the opposite land? That has also been remembered to the trial court at page number.
See, I'm constrained to hold that G. Karibasappa, under whom respondents 1 to 6 are claiming
Now,
had got changed the Kata of land in his name, claiming that he was the son of Shivapuji, son of Karibasappa.
Now, out now claim that finding itself is start.
Even though he was not the son of Shivapuji. You don't contend that you are the son of Shivapuji.
They are not.
You contend that it is G. Karibasappa.
Understood by the considered two aspects. One is find the questions raised by this number code has not been properly answered. Secondly, the lots of contesting parties were not made as parties, even though it's a part of record, they have reported before the appellate court, it's recorded in the order sheet. Two aspects, this court needs to
Who are appellant number 1 is Basamma, right?
Basamma is the daughter of Karibasappa.
Basamma. Now you have filed wakalat for Basamma. You are in. Now here in this petition, respondent number 2 is Basamma. She was appellant number 1 before the district court.
Daughters are there, Milord. Daughters are there.
Did you file wakalat for Basamma?
Basamma, I did not file, Milord. Daughters are there, Milord. Daughters are there. And Yellas are. So not to kindly see that Danamma is daughter and Gangama is daughter and other persons are illegal heirs already on record. He has not raised this contention in the writ petition. Now if I have memo, Milord, but I think that I am not being given copy of the memo.
If you serve the copy on him. See, if you have filed counsel, Basamma died before the district court. If you have filed wakalat here, because she is a party here in this proceedings.
No, I have not filed, Milord.
You have filed wakalat for whom then?
I have filed wakalat here, Milord, for Dadigamma, the sixth respondent.
So Elas of respondent number 6.
Yes, 6 I filed earlier. But then Milord, she died. Elas was brought on record.
What happened to respondent number 1 here then?
Here, Milord, 1 died.
Respondent number 2.
Two.
What happened? Where is she? Respondent number 2.
That's up there, Milord, already on record as Elas.
As far as the respondent.
This Shivapuji Karibasappa had 2 wives.
That is Basamma and Danamma. Basamma and Danamma.
Whether my Basamma's solution is the appellate of the district court is I cannot raise the issue as far as the contesting respondents are concerned, having a list over the property, those areas needs to be not on the record for the.
Which are the respondents which were concerned? You are now preferred petition now before this court. Respondent number 2, Channappa. He is died.
ಅವರೆಲ್ಲ ರೆಕಾರ್ಡ್ ಮೇಲೆ ತಂದಿಲ್ಲ before they come.
Respondent number 4 is Basappa.
ಅವನು ತಂದಿಲ್ಲ.
5, Irappa.
ಅವನು ತಂದಿಲ್ಲ. Order sheet as per the order sheet of the district court, my lord, I have filed a memo to the copies and the portion of the order sheets.
Now the present petition is by respondent number 1 and 6. Then you have made the LRs of respondent here as a party.
Before the appellate court itself, but they were not made as part.
Correct, you made them as a party here in this petition. And you have made them as a party without filing any application directly.
No, LRs have not made us.
Irappa's LRs you have brought on record here. Respondent number 5, Irappa has died and his LRs are brought on record.
They were brought on record before the appellate court itself.
ಮತ್ತೆ ಇಲ್ಲಿ ಇಲ್ಲ ಅಂತ ಹೇಳ್ತೀರಾ? See, you are not sure as to who have actually died and who have filed their application. But then you have brought them on record here. Then
So there is a even before the district court matter, there is a.
Have they filed an application for Irappa? Then how is it you filed the application for Irappa without seeking leave of the court? You serve the copy upon them. Petitioner to serve the memo dated 7/7/2015 on the learned counsel appearing for the respondent. Yes. Please on 25th. No, let us first look into the memo at least. Read the copy, number put up my dear. Yes.
Number 32, the BC Sitaramra.
Wednesday, madam. Rest all matters would be listed next Wednesday. Yes, madam, Padma Utture, what happened? 17 lakhs, 15 lakhs. Where is the other side? We'll see by 25th you mentioned. List on 25. Yes. Yes.
Number 35. The Sharapura.
Who has filed this memo for retirement? Due to paucity of time, list on 25th.
Number 36, C. Shankar Reddy.
Yes, Mr. Reddy. You are ready in this matter? Call this matter after 2 weeks. Yes, Ajay Prabhu. Ready now? You're both ready. Fine.
One has been remanded to the district commission. One has been dismissed.
Both have to go. So it has to go before the 1/4, right? Authority. Yes, 25th. 24th we take labor matters. We have only 2 days for labor matters. Yes. Harish Bhandari.
Number 38, Harish Bhandari.
No. Week after next. Chidambaram.
Number 39, Chidambaram.
Yes, Mr. Devraju, what is this? ಎಷ್ಟು amount? Has been paid. Next week, huh? Next week.
Number 40, Kempegowda.
Kempegowda, Sanjay Nair.
Like that.
25th. Yes.
Number 41, Mr. Subramanya Bhatt.
Mr. Bhatt? AEB, Devraju, what is this? Final order is already passed now. Now, there was any interim arrangement now in this. So that was to be continued. Let him challenge that order. They have to file an amendment. 25th. Shashidhara. 42 next week.
43, is here, Mohan.
Yes, Mr. Mohan.
Sought for reimbursement of the medical expenses with an extra genetic chart. Yeah, suffered head injury also. So they have suffered for further treatment. Further, the doctor has given the certificate.
How much was the claim? 25.
They have come to
25th.
Number 45, engagement.
Give your paper. The non-consideration of the representation dated 19/7/2024, submitted by the petitioner number 2 to respondent number 4. Petitioner to respondent 3 and 4 at annexure A and B has made the petitioner approach this court in this writ petition seeking a writ of mandamus for consideration of their representation. The learned counsel appearing for the respondent submits that if some time is accorded to the respondent, they would consider the representation in accordance with law. The said submission is recorded. The grievance of the petitioner would be meted if necessary direction is issued to the respondents 3 and 4 to consider the representation of the petitioner submitted at annexure A and B within an outer limit of 4 weeks from the date of release of this order in accordance with law. You take notice for whom? You have already appeared, right? Next. In the next week. Lokesh.
These matters 50 and 4 or 50 is matters. 51 is covered by decision.
Saturday hakkoli. Saturday.
All the 4 matters.
Hey, why they?
They requested last week only.
What is this, Mr.? They will not come. They have to come, right?
Otherwise, all these 4 matters.
Correct. Monday. I mean Saturday. 48, 49, 50, 51. But ಅಷ್ಟೇ ತುಂಬಾ ಇರಲ್ಲ ಅವತ್ತು. Very limited. Only date given matters.
52.
Wednesday, na? Next Wednesday. But then once, what happened to that Karasamadana? It is urgent to? It is urgent to? Let's call this matter after 2 weeks. Saturday, Allah. Let us see what happens. And either call after 2 weeks. To give me the list. Yes, Abhinav. Which is that matter? Becomes infrastructure.
Saying anyway that interim order is High Court ಹೋಗಿದ್ದಾರೆ. High Court ಅಲ್ಲೇ decide ಮಾಡ್ಲಿ ಅಂತ they direct. That is the final order. The pendency of this petition is sought to be the reason to dispose of, and that final order is also challenged.
Is this along with
5692 of 24.
5-6?
56. 56. Term order may have to be extended.
Next week, interim order granted, earlier is extended till the next date of hearing. Date given.